number 19 to 24, my lord.
Yes, what is
These
it?
are cooperative methods, my lord. For my lord holding AGM, by this time AGM hold, my lord, is first floor.
19 to 24. Jamie Chaudhary, the Learned Counsel, appearing on behalf of the petitioner, the instant batch of the petitions, submits that in view of the elections being held, AGM being held, nothing further remains in the instant petitions. If S.K. Talukdar appears on behalf of the respondent corporation partner, taking into account the above, the instant petition stands closed, maintaining orders if any stands vacant.
Lordship, I beg to mention one listing item for tomorrow, the matter ILS for eviction matters. Without similar.
Applicable. And I beg to mention for 12 of an item, my lord, or tomorrow night, there is some other.
Lordship, I like to mention matter 38 million. This is a matter of Mr. H.S. Sarkar, he is going to.
What do you want?
Mr. Sarkar. He is going to Bangalore, matter. He is ailing, he is under treatment. Therefore, may kindly be passed over, doctor.
Have you informed the other side?
Yes, sir.
Interim order? No. At the request of the Learned Counsel for the petition, matters can be adjourned to be listed after the petitions.
That is a law. I am paying for listing, my lord, eviction matter tomorrow.
May I please, your lordship? I beg to mention for listing lordship eviction method. May I please, your lordship? I beg to mention for item number 8. My senior is out of the station. Kindly inform us.
Item number?
8.
At the request of the Learned Counsel for the petition, matters can be adjourned to be listed after the petitions.
Eviction item 13, my lord. I have taken consent from other side, my lord.
Item?
13, one thing. Kindly be taken after this.
What is the matter about?
Matter about, my lord, circle officer, my lord, in 2017, my lord, issued a notice to the petitioner to vacate their land, my lord, their shops, my lord, where their land belongs to PWD, my lord. So in this regard, we came before this honorable court and honorable court stay. Now, right now, I have the instruction whether present position of documents. Only
Eviction matters. This matter needs to be disposed of. Let's see what they have done. We'll take it up.
yes.
Actually, like to mention item number 6 here, from
Huh?
supplementary. Item number 56 here. Lordship, we have filed an affidavit in opposition, lordship. The same may be called for. Pleasure. List, item 46.
Hey, please, your lord. Lordship, this is the matter regarding the unauthorized installation.
Who is appearing for BSNL?
My lord.
Yes, very difficult to find. That is why the matters have been adjourned from time to time.
My lord, last occasion actually we missed the matter actually.
Last division, every time you are not there. Now tell me, why you are having a transformer at this place?
There was an agreement in 2012. This agreement was for a period of 15 years. As per that agreement, my lord, a transformer and a BTS tower are supposed to be installed in the land. And accordingly, my lord, these were installed. And the dark number and Patna number that have been mentioned in the agreement is actually are matching the same dark number and Patna number. So on that particular dark as reflected in the agreement, my lord, this installation had taken place. So till now, my lord, they are receiving rent. This petitioner number 1 and 2, though they say that they are different entities, my lord, are essentially husband and wife. My lord, they have the same premises. So it's
Who is
now
the-
very difficult to trace if whose share of land is which and where the installation.
Who are the owners of the land?
Petitioner number 2 is the owner, my lord.
And the agreement is with the petition
Petitioner
number 2. Now what has happened?
Get a plot of land, separate compound, different duct number, Patna numbers, my lord. Now it has been installed in the premise of petitioner number 1. Admittedly, petitioner number 1 and 2,
Petition number 1 has a different plot of land.
different plot of land. It's a separate plot of land.
Where
Lordship will find that, page 16, my lord,
this agreement was entered into on 2014.
2004.
Why did you wake up so early?
No, my lord, I am a cancer patient since 2000.
Understood.
I stay in Guwahati, my lord.
Understood, but whatever may be, but why have you woken up so early?
No, I have filed this.
This is the
restriction
agreement is here. Agreement is at annexure 3.
My lord.
Now, this is an agreement for 14 years. How many years?
15 years.
15 years with increment of payout. Now, why the petitioner number 2 is before this court?
This court, that petitioner is, number 2 is having no objection if the transformer is installed in his premise. Now it has, now the anxiety is that, my lord.
But why
Petition-
did you allow it to be done?
I never allow it. It was unaware, my lord.
But you have all along allowed it, have been receiving the rent. Why have you received?
I am not receiving, my lord. My husband is receiving. It's a demarcated
Right.
plot of land.
Are you not appearing for the petitioner number 2?
I'm appearing, my lord.
Then why you are saying that you are not receiving?
Petitioner is receiving, my lord.
So therefore,
I'm
you
praying
are
for
also,
petitioner
are
number
you
1,
not,
my lord.
Mr. Counsel, are you not appearing for petition number 2?
I'm appearing.
If you are appearing, you have to say that you have been receiving.
There
Now,
might-
do you want the rent to be given to you?
No, my
Petition
lord.
number 1.
No, my lord.
Then
My only prayer before this court is to remove the transformer and put it in the premise of petitioner number 2, with whom the BSNL has executed the agreement. I want to sell the plot of land. Because of that transformer, it's obstructing the pathway, my lord. Nobody is willing to take that part of land, my lord. It's a demarcated plot of land with separate dark number and pata number, my lord.
where is the land to be situated? Patta number 172. Dark number 783.
This is regarding the land of petitioner number 2. And regarding petitioner number 1, that your lordship will find at page 16.
Now they have set it up out there in dark patta number 202.
My lord, we had set it up as per the plot, my lord, shown to us. It has been there all along, my lord. How do we know there is a demarcation, my lord? Admittedly, we have an agreement in a particular time.
There is a boundary wall, my lord.
It
There
has
is a
come-
demarcated plot of land. There is a boundary wall in between two plots, my lord.
Very difficult to tell whether it existed in 2012 or not, my lord. Might come up
No,
today.
it is a different thing.
Hello.
But the question is whether did you have it on the proper land? The agreement is with the petition number 2. It's a different,
It's a different dark.
Huh?
It's a different dark.
if it's a different dark, it's a different plot of land because your agreement categorically says dark number 783/1738 of patta number so and so. And the total square feet and the covered area is 10,711. That's the area. Now, whether there is an area there or there in petition number 2, 2's
No.
land or not.
There is a boundary wall. It's a
You
demarcated.
should have made the petition number 2 a performer respondent. You have made him petition number 2.
my lord.
There the problem arises.
Now, my lord, on behalf of the petitioner, I want to submit that I do not have any objection if the transformer is transferred to my plot of land. So as to enable the petitioner number 1, that is my wife, to sale of the plot of land.
But as you have not objected all this while, so you pay the cost for transferring. If you are ready for that, they will do it.
Place at the base of the FPTCL, my lord. We had applied and FPTCL authorities had come and made the installations.
APDCL, who is appearing?
Dixit again. Mr. Piyush Chaudhary was also there, but then he is indisposed to take over.
Admittedly, by the APDCL, it has been admitted that it has been wrongly installed, in a wrong premise.
It's a question of.
No, I'm a cancer patient, my lord. I want to sell off my plot of land. For my treatment, I cannot do that because of this transfer. Nobody is willing to take my plot of land. There is the difficulty, my lord.
But why did you wake up too late?
My
This
lord,
agreement was made when? The agreement was made in 2014. After 10 years, you have filed this petition.
I
9
have
years.
filed my representation since 2019 to the APDL authorities, my lord, in 2019. That your lordship will find. Page 38, my lord. This is my first representation in 2019.
But then also 5 years have gone by.
Again to the APDCL authorities in 2021, that your lordship will find at page 40, my lord. Then 21 again, then 22 again, my lord. Because of their inaction, I have to move to this court. Otherwise, there is no reason to move to this court, my lord.
Now, are you getting your rent or not?
Petition number 2 is getting the rent. No, they have vacated the premise. The BSNL authorities have vacated the premise except the BTS loan. That is
Huh?
admitted. The BSNL authorities has vacated the premise from the, vacated their premise, tendered premise from the plot of petitioner number 2. They've removed. That your letter, that letter your lordship could.
Petition number 2, is there any place out there? No. You see, the petition number 1's land is tag number, patta number 202. There the transformer is set up. Why will the BSNL be in petition number 1's land? 2's land.
Petitioner number, the BSNL took the rented premise in the plot of petitioner number 2.
Understood?
Now they vacated.
Then what do you have against the BSNL then?
I am not praying. I am just praying for a direction for removal of the transformer. That is my only prayer, my lord.
This agreement is with whom?
Petitioner number 2.
2 and the BS.
Agreement is with whom?
Our
So the BSNL has no business.
BSNL has no business, my lord.
Are you using that?
still a BTS tower in the place which we are contemplating in shifting. And there is a transformer which provides power to that particular tower. But then probably, as was told by my medical colleague, that transformer is also supplying power to some other sources also of PDCs. So shifting, there's no harm in shifting probably if we shift the transformer from here to there. But then since that took place initially at the behest of the petitioner, they identified and showed the land. As of now, who would bear the cost of shifting? is
Not the
not
petitioners, my lord, petitioner number 2, my lord. It was never informed to me that a transformer is going to be installed in your premise. In the premise of
Again,
petitioner.
problem arises not informed to you.
My lord.
You are again appearing for petition number 2.
I'm praying for petitioner number 1. This relief I am praying for petitioner number 1, my lord. Lordship will kindly take
Then
it.
why are you making the petitioner number 2 in the writ petition?
That may be struck off, my lord. That may be struck off. Page number 56 can.
You have by yourself complicated the entire issue. Why you are making your simple case is, look here, have installed the transformer. I have no agreement with them. Matter ends. Why you are making the petitioner number 2 a party? You should have made at best him as a performer.
I made a party of petitioner number 2 thinking of that. The petitioner number 2 is having no objection in transferring. That's why, my lord.
It will be a case of a performer responding.
My lord.
There's a difference.
Well,
I hope you are aware.
My lord, I'm aware.
Then why have you made that? So yeah. Why you are having a transformer at the petitioner number 1's place?
My lord, the petitioner entered into agreement with BSNL.
Petitioner, no, the petition number 2 entered.
That's me, my lord, we are not.
Petitioner number
We are not
2
private
entered into an agreement with not BSNL, with the telecom. Yes.
Yes. We are not private. It is the BSNL who requested us that you provide us a transformer. We need some additional power. So accordingly, they paid for it and we provide it.
So you remove it. You
It's up to them. It's their call, man.
remove it.
It can be, if it's only adjoining point, if required, it can be shifted. But
You
then
shift it as
the
per your request.
boundary demarcations and etc. When as of now, it's not even clear. But then if they identify that you shift the transformers from this location, to this location.
Shift it from there. You have no objection in
Yep.
shifting.
And they identified the happened and it was there for so many years. They have a grievance.
What to do? The petitioner as well as his counsels are in this manner. The word, proper word would be clumsy. Both. Making petitioner number 2 here. So the APDCL has no objection in shifting. And BSNL, you have no problem?
At all, it's in the wrong, if it, at all it is in the wrong, yes, madam. You're duty bound, but then that wrong happened because of, my lord.
Them identifying it.
Them,
Now, that must have been, otherwise why will they do it? Yes, what is your name?
And Gorman, my lord.
Heard Mr. N. Bormon, the learned counsel appearing on behalf of the petitioners. And Mr. D. Pathak appears on behalf of the BSNL authorities, and Mr. D. Gugoi appears on behalf of the APDCL authorities. At the outset, the learned counsel submits that the petitioner number 2 be transposed as the performer respondent in the instant proceedings. The other respondents have no objection to the same. Accordingly, the petitioner number 2 is transposed as the performer respondent number 8 to the instant proceedings. The petitioner is directed to file a fresh memo of parties before the registry of this court during the course of the day. On the basis thereof, the registry shall make necessary correction in the record of in the cause title, as well as also update the same in the CIS. The case of the petitioner herein, in view of the transposing herein, this court at this stage finds it relevant to observe that in view of the transposing of the petitioner number 2 as the performer respondent, the contents in the petition, insofar as referring to wherever there is a reference to the petitioner number 2, the same be read as the petitioner, the performer respondent. Next. The case of the petitioner herein is that the petitioner is the owner of a plot of land at measuring 0 biga 2 katha 0 lesha, covered by dark number 545, part of periodic patta number 202 in village Bongaigaon, part 5, under Bongaigaon Revenue Circle within the district of Bongaigaon. The performer respondent herein entered into an agreement with the BSNL authorities on 27/5/2014, whereby the performer respondent herein is the owner of a plot of land at measure. What is the area?
Area, my lord, 2 katha, my lord,
Petition number 2.
2, my lord, 2 katha, my lord.
How do you know?
It's in page 36, my lord. Page 36, the dark number 780 of pattern number with the following boundaries.
How do you say 2 kathas?
But that your lordship will find in the title deed, my lord. Page 52, my lord.
Page
52, my lord, the title deed.
how much?
My lord.
How are these being allowed to be? How much land? Why been not translated? এখন রিপোর্ট কোনে করছে মাথা এনেকে এখন রিপোর্টিং করে তো তাহলে নহলে
My lord, the relevant portion.
in the the
The
assistant
relevant
minister
portion only gives the names, my lord.
assistant
Schedule
minister
is
of
not-
Guwahati High Court June আছে SK Roy Chaudhary or whoever ring ask him to come. Yes. You don't know. Mr. Counsel,
My lord.
if this court is trying to help you, then also I can't help. Beginning of list this matter again after vacation. I can't help you. First of all, why didn't you type out the entire thing? The sale deed? What am I going to do with this buyer and seller name?
I have typed out the relevant portion, my lord.
What is the relevant portion of the sale deed?
Valuable schedule, my lord. It's the
Where is the schedule?
schedule.
Where is it?
I have not typed it out, my lord.
Well, you can't get it done in this manner.
I'll not repeat it again, my lord. Not repeat. I'll not.
এইখিনি এইখিনি ওপৰ এইখিনি হইলো ট্ৰান্সফাৰ কৰালৈকে হৈ গ'ল না and shall be read as so and so বুলি কয় list this matter again of 4/11/2023 at the top of the list. In the meantime, the petitioner is directed to file an additional affidavit bringing on record the translated copies of the deeds of sale of the petitioner as well as the performer respondent.
47.
Mr. Counsel, you have to help the court. also.
My lord,
You
I'm sorry.
can't come up in
I'll do
this
that.
manner.
I'll do that, my lord.
Mr.
Leave
D,
your-
এই report লিখি দিব, huh? Mr. D. Gogoi appears on behalf of the APDCL and Mr. B. Pathak appears on. Both of you be present on the next day.
The fact that it came out in the production list. Not actually, but therefore we.
Yes. Yes, Mr. Naik.
Okay, 47. I have tried my wife.
Okay, they have admitted a potential lawsuit that no notice was served to me while removing the software.
Do you have a trade license?
Yes.
Where is it?
Trade license is annexer. 5, page number 50 of the petition.
Of the
Petition, the lordship.
50. Now, if he has a trade license, isn't it necessary for you to issue a notice?
Kindly see the trade license.
Yes.
trade license subject to provisions of the GMC Act to ensure husband and husband not to come to the second line for business type restaurant having up to 15 seats near air conditioned established name of the owner. So
Now, if a person does not have a trade license, can you remove it?
Lordship will, that for that purpose, Lordship, but I would like to show your Lordship the definition of setback. Lordship.
Huh?
Definition of setback
Setback.
was erected in the within the setback line.
So
Lordship.
you exercise what power? 337.
Coming to that.
No, I'm asking you. What exercise power did you exercise?
Notice was not.
Then?
Even then not. Lordship, first of all, this is not a kiosk. It is without any wheels. Lordship. It's a permanent construction over a concrete structure.
Then you do it. Then why don't you break all the buildings which are there? How do you exercise 337? This is apparently in pagan violation.
But I am trying to say. Yes, notice was not issued.
Then,
But even if a notice is issued at this stage,
no. First of all, you have to put it back. Then you issue notice. Then you do it. This can't happen like that.
in my understanding, Lordship, within the setback line, no construction is permissible.
Absolutely, you do whatever it is. But you cannot do this.
The only point.
No,
your
you,
Lordship will
Mr. Nayak,
consider-
don't do this. You cannot do this. You cannot exercise 337 without a notice.
Mention that we have done that as per 337.
What power did you exercise?
Specific.
The moment you come to the setback, it is 337. Otherwise, you have no other power. What other power? Show me.
That is why I am submitting, even if a notice is issued. Now, I am trying to say that it is a futile exercise.
So what?
A notice is issued, you will not be able to prove that it was constituted.
Then why don't you break all the buildings? Wherever you find, if somebody gives you a call, the additional secretary gives you a call, "Hey, that building is bad. Why don't you break it?" Or somebody raises a complaint, why don't you break it?
The authority went on the 11th itself. Nobody was there. On 12 also daytime, during daytime.
And why do you do at night, 12 o'clock?
It was because it was lifted with the help of a crane. It
So
was lifted.
does it mean that you are going to do at
During-
night?
During daytime, it was not possible.
Is it permissible? As per the enforcement and as per the GMC will do it at night.
I thought. They work day and, both day and night. That is not the issue.
But that is also the issue. First of all, this is a case by which, it is a case by which the GMC authorities have resorted to all hooliganism. I may use the word.
Use the word, but my only point is, first, it is not a kiosk as submitted by the petitioner. Secondly, the trade license is clearly showing that it is not in respect of that structure Lordship, because.
So
it
if
was
he
taken-
doesn't have a trade license, you
Problem.
can seal it. You can seal it, but you cannot remove it. The only way to remove it is only if you go by the question of there is a violation to the building bylaws or anything out there.
Lordship,
But you have to issue a
they were
notice.
Also not running the same, it was merely, it was simply constructed before that pharmacy Lordship, and it was not even open. We were not running the business. On 2 occasions, Lordship authority went there, nobody was found.
Lordship, the owner of the kiosk, the Mutwali, he resides a few walkable distance besides the kiosk.
Mutawalli is not the owner of the South
Lordship,
Lordship. He is the
he is-
petitioner number 3.
He is the lessor, your Lordship. Petition number 3 is the lessee, your Lordship. The owner of the shop is the Mutwali. your Lordship.
Now, let's see what is the complaint given by Archana Das on the basis of which you have taken the action.
Case 64 Lordship. Yes, sir.
What does he say?
And
If we
illegal
go by the
container-
fact that you say that it is not a shop, it is just a building.
They constructed it as a shop Lordship.
No, understood. If it is not a shop, then it is a case of question of trade license doesn't. If it is a case that it is a shop, a trade license will come. Or if it is anything else being kept out there, what business does the GMC has to remove? Unless you ask the owner of that place, did you issue any notice to the owner of the place where the locality is? You may not know the petition number 3, but you have to know who is the owner of that area. Can you do that? Yeah, and more so when the notice categorically mentions who was the person who has done it. See, placed in front of my business premises by the officials of our premises regulator Anwaruddin Waqf State. Why didn't you issue the notice to Anwaruddin Waqf State? You knew it. You acted on the basis of this document. And then also this has happened.
Lordship, no issue, Lordship. Lordship director will simply place it there again. But then we will again issue a notice.
Do no. You issue notice whatever you do.
Lordship,
But the fact remains that you have to do anything if you want to do, you have to do it as per law. But not as per the high-handedness or somebody giving you a call. This is what has happened.
not just because of the call.
Yes.
Written complaint is also
A
there.
complaint is there, but how many complaints do you do? How many places have you removed? Should I ask this commissioner to file an affidavit on that basis that how many places have been removed on just on the basis of a complaint like this?
In this case, there was.
You can't do this.
They can take back the property, whatever.
You have to put it. Not they have to take it back. You have taken it, you have to put it. Why will they take it back? You have to put it there. Thereafter, you take whatever action. That is your look. But you can't do this. Law is law. Now, heard Mr. A. Ali, the learned counsel, appearing on behalf of the petitioner. Mr. B. Nayak appears on behalf of the respondent numbers 1, 2, 3, 4. And Mr. HUF, you appears 5 also, na?
5 Lordship, Assam Board of.
No, 5.
Department, yes, Lordship. Housing and Urban.
On behalf of the 5. The instant writ petition has been filed by the petitioners. Complaining about the high-handed actions on the part of the respondent authorities in removing the kiosk/shop of the petitioners, including the goods therein, at the middle of the night from the petitioner number 1's premises. That too without issuance of any notice. It is the case of the petitioner herein that the petitioner number 1, which is the Anwaruddin Waqf estate, in this case of the petitioners herein, that a plot of land at measuring 3 bighas 3 kathas and 9.93 lechas, covered by DAG number 1498, 1500, 1502, 1503, 1653, 1654, and 1655 of KP Patta number 585 under Moza Ulubari of village Ulubari in the district of Kamrup Metro Assam is a part of the petitioner number of Anwaruddin Waqf's estate. That is the petitioner number 1. The said plot of land is adjacent to the GS Road at Bhangagarh. In the said plot of land, the petitioner number 3, in the said plot of land, the petitioner number 2, who is the Mutwali of the petitioner number 1, had leased out a kiosk/shop to the petitioner number 3 in order to allow him to open a shop to carry out food and beverages business. In that regard, a tenancy agreement was also entered into between the petitioner number 2 and petitioner number 3. To the utter surprise of the petitioners, on 12/7/2000 at midnight of 12/7/2024, that is on 11th night,
12th
12 or 13th.
12th night, it started around 11:30 PM and around 11:30 to 12:30 PM.
So it is in between 12 and 13.
Yes.
It is to the utter shock and surprise of the petitioners at around 11:30 PM on 12/7/2024, without any notice whatsoever, some persons forcefully removed the kiosk shop of the petitioners. The said acts were committed on the basis with the help of a hydraulic crane bearing registration number AS01DS8321 and a dumper truck bearing registration number AS01QC9459. On the basis thereof, an FIR was filed at Bhangagar PS police station, which was registered and numbered as Bhangagar PS non-FIR number 21/2024. Subsequently, to the shock and subsequently, the petitioners could come to learn on further inquiries and a communication being issued by the collector of the Guwahati Municipal Corporation that the said action was taken at the behest of was taken on verbal instructions of one additional secretary to the government of Assam of the Department of Urban Affairs on the ground that during field inspection, no trade license was found. This aspect was duly intimated by the communication dated 17/8/2024. The contents of the said communication, page 54, is reproduced hereunder. It is under such circumstances the petitioners have approached this court alleging the high-handedness on the part of the GMC authorities. That too, on the basis of verbal instructions being issued by an official of the Department of Housing and Urban Affairs. This court, by an order dated 13/9/2024, issued notice and directed the respondent authorities to bring on record their stand by filing their affidavit. In accordance thereto, an affidavit was filed on 25/9/2024 by the Joint Commissioner, Guwahati Municipal Corporation. The contents of the said affidavit, however, differs from the contents of the communication dated 17/8/2024, which have been quoted herein above. In as much as something more, in as much as it's certain additional aspects were brought on record by filing the said affidavit. A perusal of the said affidavit reveals that a complaint was received by the collector of the Guwahati Municipal Corporation on 11/7/2024, submitted by one Archana Das, alleging inter alia that an illegal container shop was placed in front of her business premises by the officials of the petitioner number one without any prior notice. And the collector, Guwahati Municipal Corporation, was therefore requested to remove the illegally placed shop from the rented premises. Full stop. It has been further mentioned that on the basis of the complaint submitted on 11/7/2024, the enforcement branch of the GMC conducted an inspection on 11/7/2024 itself and could not find the owner of the shop, that is the petitioner number 3, on the premises. Subsequently, the GMC authorities again revisited the aforesaid movable shop on the very next day. But the petitioner number 3 remained missing. And as such, the GMC was unable to inspect the trading license of the petitioner number 3. It was also mentioned that the said container shop was placed in such a manner that it blocked a part of the front of the establishment belonging to the complainant, Srimati Archana Das. And considering that it was causing a hindrance to the business of the complainant, the enforcement team of the GMC removed the same with the help of crane in the night of 12/7/2024. It was also mentioned that the additional secretary to the government of Assam, Department of Housing and Urban Affairs, had also issued instructions to the concerned officer of the GMC in that regard. Full stop. Pursuant to the filing of the instant writ petition, affidavit, an additional affidavit was also filed. Wherein the details were placed as regards the contents of the kiosk oblique shop. And the value thereof. How much is the value?
It comes around 3 lakhs, around 3 lakhs thousand, around. Because the.
So you
particularly
want this court to make this calculation? No, no. Was my order not clear?
Yes.
Then
I will make that, I'll provide the code.
not necessary. Pusto. I've heard the learned counsel in the backdrop of the above. I've heard the learned counsels appearing on behalf of the petitioner as well as the respondent authorities. Mr. A. Ali, the learned counsel appearing on behalf of the petitioner submitted that this is a case of extreme high-handedness on the part of the respondent authorities. In taking such actions. Which is not contemplated as per law. He submitted. That if there is he submitted that in the communication dated 17/8/2024, the collector of the Guwahati Municipal Corporation, who is also the deponent of the affidavit so filed, did not make a single whisper as regards a complaint being filed by Archana Das, owner of the Lasit Medicos. However, subsequently, in the affidavit, it is being shown that it has been done at the instance of MS Archana Das. The learned counsel appearing on behalf of the petitioners further submitted that even assuming a complaint was filed by Archana Das, it is an interstate dispute between the petitioner, between the said Archana Das and the petitioner number 1 and 2. And the GMC authorities ought not to have intermingled in respect to the said dispute. Per contra, Mr. P. Nayak, the learned counsel appearing on behalf of the petitioner, respondent, authority submitted that upon receipt of the complaint submitted by Srimati Archana Das on 11/7/2024, the enforcement branch of the GMC had visited the premises, visited the shop of the kiosk on 3 occasions, 3, na? 2 occasions, but did not find the petitioner number 3 and could not therefore verify the trade license. He further submitted that the place at which the area wherein the kiosk was set up is in violation to the setback as provided under the Guwahati Municipal Corporation Act, as well as the building bylaws. And as such, the respondent authorities have committed no illegalities in removing the kiosk. Anything else?
That second point was, even if a notice.
Huh?
Even if a notice is issued.
That I'm putting it. No, that I will put it when I put the query. I have to put it, not the query. Then your answer will be, no, as your argument is this.
It was not like a kind of a kiosk lot, it's a permanent construction. But on a concrete structure, it was, above a concrete structure. It is a kind of permanent structure.
He further submitted that the structure standing thereon was not in the form of a kiosk, but a concrete, but was set up over a concrete structure. But was attached to the land. But was attached to the land with concrete. Full stop. This court heard the learned counsels appearing on behalf of the parties. Full stop. During the course of the hearing, this court inquired with the learned counsel appearing on behalf of the respondent authorities as to under what power such action was taken by the respondent authorities. Inasmuch as not having a trade license, the respondent authorities could have at best sealed the premises, but could not have removed the premises. The learned counsel appearing on behalf of the respondent authority submitted that the shop which was attached to the art by concrete was in violation to the setback. And as such, the same was done. And as such, the said action was taken. In view of the said submission, this court put a specific query upon Mr. P. Naik, the learned counsel, as to whether such an action is permissible without notice, taking into account that the said action appears to be an action taken under section 337 of the Guwahati Municipal Corporation Act 1971. The learned counsel for the respondents authority submitted that the issuance of notice would not have made any difference, taking into account that the conclusion which can be, the only conclusion which can be received, could be arrived at, is on the basis of, is that there was a violation to the setback. In that regard, he has referred to the judgment of the Supreme Court in the case of Aligarh Muslim University versus so-and-so, reported in 2007 SEC page. It did. In the backdrop of the above, this court had given an anxious consideration to the materials on record, more particularly the communication dated 17/8/2024, is absolutely silent on the question of any complaint be submitted by any person except a verbal instruction being given by an high official of the Department of Housing and Urban Affairs. It is relevant to take note of at this stage the judgment of the Supreme Court in the case of Govardhan Das Bhanji versus Commissioner of Police, Bombay, reported in AIR 1951-52 Supreme Court SC page 16, wherein it was categorically observed that public orders made has to be tested on the basis of the reasons contained therein and not on the basis of any affidavit filed subsequently. The same aspect of the matter have also been reiterated by the Constitution Bench of the Supreme Court in the case of Mohinder Singh Gill versus Election Commission of India, reported in 1978 2 SCC, page 2 DD, wherein at paragraph number 8, the Supreme Court held as follows. First, from the above propositions of law well settled, and taking into account the say to the present case, it would be seen that the action which was taken by the respondent authorities was at the behest of an high official in the Department of Housing and Urban Affairs, Department of the Government of Assam. The same, therefore, on the face of it shows, and on the verbal instructions of students, the same, therefore, show that the respondent authorities have acted arbitrarily and in a manner not envisaged under law. The manner in which such steps were taken by the GMC authorities, that too at the midnight, without serving any notice, that too at the midnight of 12/7/2024, is not what an authority established under the provisions of the Act, an authority established under the provisions of the statutory enactment is required to follow. In the backdrop, this court further finds it relevant to take note of the fact that as regards the complaint so filed by Mrs. Archana Das, complaining about setting up the shop container in front of a shop. In the same complaint, it was categorically mentioned as to who has done it. It was categorically alleged as to who has done it. It is appalling to take note of that the respondent authorities even did not care to inquire with the respondent authorities, with the petitioner number 1, against whom such allegations were made before taking such action. It is very surprising to take note of that in the complaint, so submitted by the respondent number 3, by the petitioner, by Sri Archana Das, there is no mention whatsoever as regards the petitioner number 3. But surprisingly, in the affidavit so filed, there is a reference being made that the JMC authorities, the enforcement branch of the JMC authorities, were rather looking out for the petitioner number 3, but did not take any steps insofar as the petitioner number 1. The above therefore shows that this is a case of high-handedness resorted to. In apart from that, this court also is shocked and surprised in the manner in which certain private disputes between the petitioner, between the Srimati Archana Das, as well as the petitioner number 1, is being sought to be settled by the GMC authorities. The same seems to have been influenced by the verbal instructions so given by the additional secretary of the Housing and Urban Affairs Department, as have been categorically mentioned in the communication dated 17/8/2024. Under such circumstances, this court is of the opinion that the manner in which the respondent authorities have taken action is illegal, arbitrary, as also speaks of high-handedness on the part of the respondent authorities. Accordingly, this court therefore directs the respondent authorities, more particularly the commissioner, more particularly the respondent number 3 and 4, to forthwith and within 48 hours from today, from the date of the instant order, return, place the said kiosk at the kiosk/shop at the place from where they have taken, and file an affidavit of compliance within 7 days from today. With the above, the instant petition stands allowed.
That 7 years period not will extend for vacation. Will not be. Will be returned. After the vacation,
No.
I try to take it.
No. You are to, otherwise, what will happen to all this while? You are to file your affidavit because the vacation court is open, no?
That is the, it will be filed and we will comply the order. Okay, we will comply.
You have to file your affidavit of compliance. This is not done. Mr. Naik, this is absolute. In fact, you see, yeah, I can very well refer to that recent Supreme Court judgment also. This is a case of bulldozing, which we have done.
Paying for one observation only, not about it.
Yes.
Granting the authority the liberty to as per provisions of the.
Needless to mention that after due compliance and filing of the affidavit, the respondent authorities would be at liberty to take such action as permissible under law. 7 days, file affidavit. Unofficial. Oh, okay. Allow for it. It's not one available. It's not one document. If one document is typed in media, it's something which I think for itu नाम तो लिखी थी के पास कोई लिखी बात नहीं क्यों कितने के साथ तो पता नहीं है यदि टाइप करो देखा ये प्रमोट कर रहा है तो ये था itu no puedo So you have to bring the entire thing document for another from where the thing of relevance. It is very different. It is a good part of the people in order to be able to do it. The people immediately is not active. The past people would be very famous to them. Even to describe the relevation we have to do, the different actors are not even really something of it. Effectively. Effectively, bench side more data problem.
For motion item 1 to 4.
Yes. What is this? 2021 motion still going on?
Yes, Lord.
Why?
No response has been received.
Are both sides. So and so. What is your case?
Non-issuance of PDS license, Lordship.
In issuing preference to the similar petitions supporting between the terms of the thing. What is this PDS license business?
Lordship, is number 16 of the fifth.
This file was in lost and found.
Check.
The file was in the lost and found.
No, Lordship.
Then why? Why after 2021 the matter has come up for motion?
Lordship, notice was not issued.
Let's see, whatever may be.
It was tried to be disposed of
What do you want here?
issuance of to issue PDS license, Lordship.
Why?
Page number 16, Lordship.
No, whether you are, what right do you have?
Because we are directed to apply for a PDS license, Lordship.
But then,
Thereafter, they have not issued. Lordship. We are,
so anybody who applies, they have to get it.
no, Lordship, we are cooperative society and the Register of Assistant Register of Cooperative Society has directed to apply us for PDS licenses. Page number 16 of my petition.
Form of certification, when did you apply? Yes. Submission of MC resolution, these have gone long time back. Then, what do I do? Prayer for PDS. Above, I have the honor to state that as per your letter, a meeting of the executive of the was held on 15 regarding PDS license. That in the two meetings, there are a number of proposals passed unanimously for getting in. Mr. Counsel, don't you think that you need to update it now? You are basing upon a prayer for PDS license of 2015. Apply freshly. Because now circumstances have changed. I give you the liberty. You apply freshly and they will consider. I think that is a better option.
Lordship, we have applied pursuant to direction to apply us, Lordship. Page number 16 of the
Page number?
16, Lordship.
Now that is I have seen. With reference to the Iman of the Iman, I am to inform you that LPO Iman for issue of Iman in this issue, you are asked to take resolution in the MC and submit the same to the undersigned for accord approval and onward submission to the SBI for Iman. Now thereafter you submitted,
Yes, Lordship.
you gave it to the, why did you say place it before the SDO?
As the, we have placed.
You have to give it to these people only, the assistant register. And then he is going to forward it.
Assistant register has forwarded, Lordship, page number,
Where?
page number 18, Lordship.
Page number 18. From Medoc area to so and so, with regard, I have the honor to hear the license of Iman. Then,
There
this
are-
was in 2015.
Yes, Lordship.
Why have you filed the writ petition in 2021?
We are pursuing that, Lordship.
No, what is this pursuing? Pursuing means you absolutely delay in latches. This is a case where therefore you are not entitled to anything. Therefore, now, Mr. Counsel, kindly appreciate, now the circumstances have changed. You need to freshly apply. I give you the liberty to freshly apply properly after taking whatever. As of now, is it known what has happened? Because this is of 2015. Writ petition was filed in 2021.
21.
We are in the year 2020.
Lordship, it's-
You were there.
Instruction is there, Lordship.
What instruction? You cannot, I know, but how on earth such things can happen? As per this, you have no case.
Okay.
Two options. Option number one is taking into account that many years have gone, you initiated in 2015, you want to take a fresh proposal. Second. The second is their stand. GPSs are registered under the Assam Cooperative Society, which is implemented by the Corporation Department, not by this department. Therefore, Corporation Department may give any business to their registered societies other than PDS sub wholesale license. Food Public Distribution and Consumer Department is not bound to issue PDS sub-whole license to all GPSs created or registered under the Assam Cooperative Society Act 2007. The department issues PDS license to GPSs if found necessary for the concerned area. Then we dismiss it on the, I have so many options. Dismiss it on the ground of latches. Dismiss it on the ground of this. And third is giving you permission to again apply if you feel that.
Yes.
Which one? Look, গোটেইকেইটা is same.
Yes,
All
yes,
three are
yes.
four are same.
Even if GPS's name is different, there is.
All these cases are same.
Same.
এটা লিখি দিছো গোটেইকেইটা বেলেগ বেলেগকে লিখি দিছো। Heard Mr. A.D. Chaudhary, the learned counsel appearing on behalf of the petitioner. Yes, Corporation Department, who? Where is the Corporation Department counsel? You are a Corporation Department counsel. Or appearing on behalf of a Corporation Department and counsel. Which one? On behalf of would not do. I'll put it none appears for corporation. None appears on behalf of the Miss so-and-so appears on behalf of the respondent number 6, respondent number 2, 1, 2, and 6. 1, 2, 3, and 6. None appears on behalf of the Corporation Department on call. The instant repetition is taken up at the motion stage for disposal, taking into account that the repetition was filed in the year 2021 until date, and the instructions have also been placed before this court. From a perusal of the repetition, it reveals that the petitioner is a society, petitioners is a society, is a cooperative society registered under the provisions of the Cooperative Societies Act, Assam Cooperative Societies Act 2007. Pursuant thereto, the petitioner had sought for being issued a PDS license and was forwarded by the Assistant Register of Cooperative Society on 22/6/2015. So the records of the instant writ petition, in the records of the instant writ petition, there is nothing mentioned as to why after 2015 and why after 6 years from 2015, the petitioners have approached this court in the year 2021. Be that as it may, it is seen that the petitioner herein applied in the year 2015 and the writ petition was filed in the year 2021. And at present, as this court takes up the instant writ petition, almost writ petition, it is writ petition. Another 3 years have already passed by. Full stop. The legal counsel appearing on behalf of the petitioner submits that various further changes may have taken place in the meantime. And as such, taking into account the above, the petitioners would be better, the petitioners would be well advised to apply freshly for the PDS license if the petitioners are further interested in getting the license. Full stop. Taking into account the above, this court, without going into the merits, disposes of the instant writ petition, thereby closes the instant writ petition in view of the submissions made by the learned counsel for the petitioner. Full stop. It is made clear that closing of the instant writ petition would not be a bar or cause prejudice to the petitioner in freshly applying for the PDS license, if so advised. Madam, I don't consider counsels who appear on behalf of counsels. Okay? Tell you.
Please, your lord.
Alexa?
Page 16 doors. 65 doors. With all respect, lord.
Yes.
With all respect, lordship, the notice dated 22/7/2024 issued as per order of the Principal Secretary Karbi Anglong Autonomous Councils by the order so and so, Miss so and so dated 26/24, directing the petitioners to remove all the houses and other materials from the land mentioned within a period of 3 months, following which legal actions will be taken and petitioners will be forcefully evicted from the land by law. And maintainability of such eviction notice as the land in question is periodic Hiraspatta and the right title and interest of the private respondent as well as petitioners are involved and the land is admittedly not combined land. Lordship, with all respect, Lordship, I want to peruse the notice. Lordship, notice does not carries any, Lordship, the under what circumstances notice was issued, what is the contents of the notice, why this notice was issued, Lordship, notice is totally silent. In a routine manner, Lordship, earlier 2 occasions also that Honorable this court stay was given in 2 cases, Lordship. Same footing, I am also, Lordship. Now it's a strange, Lordship, in Hindi-speaking persons, Lordships, issued the notice and deprived their rights, Lordship, in Karbi Anglong.
So what to do? You have to go and challenge the act,
Lordship.
challenge the act. These are 6 scheduled areas.
Yes, Lordship.
What to do?
The petitioners are, Lordship, their full feathers,
The
but
6 scheduled areas categorically, and that act categorically says that no person can out there own land or occupy land without any permission. What to do? Your predecessor was asked the same question. He ran away, putting the baby to you. Isn't that, Mr. Sudhir? Didn't I put the same question to his predecessor? He gave away. And, huh?
This is the act, my lord, that has been enacted, my lord. And this is the provisions of section 5. He has not mentioned anything about the section 5 in the petition itself. What is section 5 of the Karbi Anglong Transfer of Land Act 1959?
And you got so much of time. Why didn't you reply to them and ask them? Why you are coming before this court?
Lordship,
Too
earlier
much time.
2 occasions, the parties filed the writ petitions, Honorable High Courts, and High Court directed to approach before the Karbi Anglong Autonomous Council, Lordship. And accordingly, the petition was filed and no actions yet been taken, and pending dispose of the Honorable High Court's order, Lordship, issued this notice, Lordship.
Earlier, my lord, direction was issued to the executive member in charge, my lord, to dispose of the representation about cancellation of Pata. That has already been, my lord, order has been passed by the executive member in charge. Earlier, on, your lordship asked that question, my lord, already, my lord. That has been disposed of, my lord. That order is with me, my lord.
The last time when it came, I asked him as to what happened pursuant to Justice B.K. Sharma's order. So they have
That has been
cancelled the
disposed of.
Patta.
On cancellation of Pata, they have had an application for cancellation of Pata to whom the Pata was issued, with tribal people, my lord. They have asked for cancellation. That application was rejected.
Then
When we approached before the Sir Karbi Anglong Autonomous Council, we filed the petitions, Lordship, and still filing this petition after receive this notice, Lordship. No notice as Lordship. Even we have submitted
I
that
can-
our High Court directions till no action yet been taken, but they didn't any importance, Lordship. They issued
after
this
this notice, why didn't you approach them and say there, then look here, my appeal is pending, my Patta is pending, all the High Court's directions have not been complied with. So do something.
My lord, they may, that order is there, my lord. They may challenge that order, my lord, regarding the cancellation of Pata, and they have asked for allotment settlement of land. We have the executive member in charge as per earlier order, my lord, that has been disposed of. I can hand it over him to also a copy, my lord. He's at liberty.
Order was passed in the land appeal on 22/7/2020. And what it means?
And with all respect, Lordship, the notice as per order of
Counsel,
the,
you do one thing. Go and file whatever you find.
my lord, principal authority is the highest authority of KSC, Lordship. And principal authority issued directions issued this notice, Lordship. Then where to go, Lordship?
No, okay, but you will go for what?
Lordship,
What is your right? Show me some semblance of right so that I can protect. Show me some semblance of right somewhere.
the land possessed from 1962 lordship. We have
That would not give you a right.
and purchased this land, my forefathers lordships. And we are,
Purchased by how?
now we are lordship peacefully, they are living and enjoying that land lordship. And after my lord, when private respondents come lordship and interfere this, and then lordship start this problem lordship. And last 20 to 25 years lordship petitioners are enjoying this land lordship without any hindrance lordship.
Understood, but show me some right and accrued upon you, I can protect. Show me some right.
We are regularly paying lordship,
What are you paying?
revenue slip lordship, revenue.
Show me that.
Yes, sir, one.
Where?
Page 19, lordship, annexure 3. Page 19, page 20, 21 onwards, lordship.
These are when 85.
Yes, lordship.
No, regularly we have to understand now, not 20, 35 years of that. Regularly now, you are all, these are all 1985, 88, 89, 91, 92, 92. Then no more. After 92, what has happened?
They,
Regularly.
they have stopped to
So,
collect the revenue.
so in 1992, your right has gone. Did you ever challenge that? The 1992, they have stopped me. So kindly give me. Tell me, how do I protect you?
That is Toji Baki revenue, my lord. That one, page 31, that is Toji. We are paying the
Page
Toji Baki
55.
revenue. Page
Page
31.
55, lordship, with all respect, lordship, there is a direction for the Honorable Guwahati High Court to maintain the status quo, lordship.
Page?
Page 55, lordship. 53, 55.
Where? Page 50?
53, 54.
In the meantime, as regards the land,
Yes, lordship.
that is,
Last question of question 54, lordship. In the meantime, status quo as regards the land in question as on today shall be maintained by the parties.
understood, but thereafter what has happened? Your marriage petition has been disposed.
56. Page 55, 56, lordship. As it
56,
may-
your
it
petition has been
open to the
disposed.
petitioners to peruse the said remedy as well, MC stand dispose of lordship.
Well,
Then appeal was filed lordship before the case.
the appeal has been dismissed. 2020. Therefore, I am asking you, where is your semblance of right?
But no hearing, no notice lordship. We are totally in dark regarding this.
So you challenge that order? Where your land appeal number 1/2019, all these land appeals have been given. You have to challenge that. Challenge it before the appropriate authority. Against that appeal lies where?
He may approach the executive committee, that is a cabinet, my lord, executive committee of the Karbi Anglong Autonomous Council.
Then
Then he can board of revenue.
would be the Board of Revenue. Challenge this order. They still have the power of the 151.
That is one aspect, my lord. Another, this present notice is under section 5 of the Transfer of Land Act, not under Karbi Anglong Land and Revenue Act. I think our John Lordship dealt with my lord Punapur incident, my lord, and regarding the tribal bill and block, my lord. That Lordship has passed an order on that also, my lord, under chapter 10. And the Karbi Anglong Autonomous Council itself is a tribal area under Article 244, my lord. And there is a provisions in that chapter 10, my lord, settlement rules, my lord, framed under 161 of chapter 10, my lord, that eviction of from the person concerned under Rule 12 also.
Rule?
Settlement of the rules framed under 161 of the chapter 10.
You have a different rule.
Different rule, there is the Assam Land and Revenue Regulation, my lord. On that date, Lordship has not dealt with that point, my lord. That point is also there, my lord.
Which one?
Chapter 10, my lord.
Hmm.
Section 161 provides for making a rule, my lord, and accordingly, under the Assam Land and Revenue Regulation, my lord, rule was also framed for eviction from the periodic quota also. That is there, my lord.
So the rules goes against 165?
No, 161, under 161, my lord, 165.
161, you can make the rules, but does it say that you can evict anybody under 165(3)? No, you cannot unless you follow the procedure of 165. Because obviously the rules will be subservient to the act.
Act, my lord. There provision of, there is there, the rule 12 for power to evict, my lord, from the periodic quota also.
There's a separate rule. What is the name of the rules?
And Assam Land and Revenue Regulation itself.
Which rule?
Settlement rules framed under section 161 of the Assam Land and Revenue Regulation.
There's a separate rule, not the settlement rules.
Separate rule, my lord.
It is in that book.
That's book, my lord.
You're referring to which one? Karbi Anglong?
No, Karbi Anglong, my lord, it is Assam Land and Revenue Regulation, my lord.
Which rule you are referring to? One 161 does not say about making rules. Measures may include constitution of a compact area in regions predominantly peopled by the people of the boundaries of the area so constituted as compact area. 161 is only, and that is why the 1950 order had come in.
If any person is found in occupation of any land held under a periodic lease, otherwise than in accordance with the provisions of this rule, he shall be evicted therefrom.
Where?
And that is the rule framed under section 171 of chapter 10.
Rules. Where, which portion you are reading?
Land and Revenue
Which
Revenue
rule?
Regulation 1886, my lord,
Which rule you are saying?
under section 171. There is chapter 10. This is the book, my rule 12.
You are referring to which rule? He shall be evicted therefrom, not forfeit. Because
Therefore,
therefore I'm saying, it cannot be, because otherwise it will go against 165(3). 165(1) says about any trespasser. 2 says about annual leaves. 3 says about periodic. Periodic, you have to follow 165(a)(b). So therefore it is said, for the purpose of eviction, will serve a notice requiring the occupant to vacate the land and to remove all this crop, and such notice shall be served on one or the more and cannot be found if it is sufficient and so and so. Fails to vacate the land and so may forcefully enter into the land, any disobedience in all matters.
so that power is there after serving notice, my lord. That
No,
if
that
the-
is there.
my
This
lord,
power is there, but this
That's
power is
good.
already there in
my
165(3).
lord,
That is why I'm saying. The word forfeit is not there. What? But yeah, there you have given 3 months.
Here, we have already given them 3 months, my lord. That is under the Transfer of Land Act, my lord. There is another act, my lord. There is a page 15 of that book, my lord.
Page,
Page 15, section 5. Mikir Hill, that name has been changed, Karbi Anglong District, Transfer of Land Act 1959, section 5.
vacate within 3 months from the date of PR. So then, what to do?
So, notice
Not
was issued
the-
under this act, my lord.
There's no appeal, na?
No, no appeal, my lord.
Then where will you go? Read. Show me some semblance. Mr. Council, why don't you do one thing?
Appeal. we
Go
can
and
file an
challenge this appeal order.
Executive committee, my lord. I can
This
send over the
order,
committee,
you
my
challenge it and ask for stay.
stay, my lord.
That is a better option. How do I do this? Because this is a consequential to this. So unless this order is not set aside, this will keep on happening. Because this is in consequence to this. Obtain possession or without any authority and then liable to be anyone, this is it. So unless you challenge this order of 22-7, this is only for Parmananda Bhagat and Ramayan Chauhan. 2 petitioners. How many petitioners are here?
10 petitioners. 10. No,
What about the others? Did they file appeals?
no, here only 10, lordship.
All these 10 petitioners, did they file appeal? No.
Yes, lordship.
Show me. Because earlier it was, as per the court's order, was Parmananda Bhagat and another. There were only 2 persons. These are the 2 persons. You see, Parmananda Bhagat and Ramnayan Chauhan. And these are the 2 persons who filed the appeal.
So,
Mr. Counsel, you have to be ready with your matter.
But died. Parmananda Bhagat died, my lord. So he's,
Unless you don't challenge this order, you have no case. What to do?
yes, lordship. Agree with the court, lordship. In the meantime, lordship,
No in the meantime.
find the appeal, lordship. Protection
my
mechanism.
lord, there is no action, my lord. Time has already been granted, my lord, 3 months, still 21.
File
PM.
it.
In the meantime, he can approach, my lord.
You still have a month time. 22-10, na? You'll be evicted on 22-10. File appeal wherever you feel like.
Kindly give a observation, lordship, with all respect, lordship.
The petitioner is herein. But the appealer is only one. Filed by 2 persons. Others have not filed appeals. So under such circumstances, I don't know what rights the others will have. The others can go before the executive, this executive person. But he can't go before the executive, yeah, because it is done at the behest of the principal secretary. What will happen to the others?
Petitioner, while earlier petitioner was Paramananda Bhagat.
There are
He
two
died.
petitioners.
He died, my lord. So, this petition is filed by his son, my lord. That is petition number 126.
1 to 6.
Is
One
the
is the
son of Paramananda
Paramananda
Bhagat.
Bhagat.
Okay.
And the Ramayan Chauhan, that
Ramananda-
another petitioner is alive.
Well, number 8, 9 and 10.
Yes, Lordship.
That Ramayan Chauhan is, my lord, he is the, my lord, second petitioner of the.
That I
earlier
have
case.
got it. But who is Adej Chauhan? He's a son of, yeah, so they are here.
Yes, Lordship.
And
Yes.
here is Rajesh, wife of Rajesh Chauhan. Rajesh Chauhan is who? How is he connected? Rajesh Chauhan.
Son of Paramananda Chauhan, Lordship.
Paramananda is Bhagat.
Brahma Chauhan.
126.
126.
126, the
Okay,
son of the.
And
Paramananda
Mr.
Bhagat.
Yes, your name?
Brahman, ML Lordship.
So and so, the learned counsel appearing on behalf of the petitioner, Mr. J. Sutri appears on behalf of the Karbi Anglong Autonomous Council as well as its officials. The petitioners herein have been aggrieved by the petitioners herein are the petition number 1 to 6 herein are the successor in interest of late Paramananda Bhagat, of one Paramananda Bhagat since deceased. The petition number 7 to 10 are
7 is the different person. Parama,
7 to 10.
7 is the different person.
7 is the Ramayan Chauhan, na? That person whose Shreya was there. Petition number 7 to 10 belongs to the same family of the petition number 7. This is the second round of litigation before this court. Because earlier, the petitioners were issued notice in the year earlier. The predecessor in interest of the petition number 1 to 6 and to respondent number 7, petition number 7, an order was passed by the Joint Secretary of the Revenue Department of the Karbi Anglong Autonomous Council by the communication dated 21 earlier. A communication was issued by the Joint Secretary Revenue Department of the Karbi Anglong Autonomous Council dated 21/2/2011, whereby the ARO/ASO were directed to hand over the possession of the land in question to one Parthe Pangcho, which is who is the respondent number 5 in the instant proceedings also. On the basis of the said communication dated 21/2/2011, notices were issued by the Assistant Revenue Officer dated 21/7/2011, asking the late Paramananda Bhagat as well as the petition number 7 to vacate the land in question. The said petition, the said notice dated 21, and the said communication dated 21/2/2011, and the notice dated 21/7/2011 were subject matter of a challenge before this court in WPC number 4014/2011. Initially, this court, by an order dated 6/8/2011, issued notice 11, directed the parties to maintain status quo. However, subsequently, by an order dated 6/5/2023, the petitioners of WPC number 4014/2011 were granted the liberty to file an appeal against the appeal before the executive member of the Karbi Anglong Autonomous Council. Although there has been nothing mentioned in the writ petition there, it is categorically mentioned in the writ petition that late Paramananda Bhagat as well as the petitioner number 7 filed appeals before the executive member of the Karbi Anglong Autonomous Council. However, the petition is completely silent that the said appeal was registered as a land appeal number 1/2019 and was dismissed by an order dated 22/7/2020. This order was placed before this court by Mr. J. Sutia, the learned standing counsel of the Karbi Anglong Autonomous Council, along with an instruction dated 21/9/2024. The same is kept on record and marked with the letter X. This court had duly taken note of that the appeal which was filed by the predecessor in interest of the petition number 126, as well as by the respondent by the petition number 7, were dismissed by the executive member. And directions were issued that actions be taken and that eviction proceedings be initiated under Section 5 of the Karbi Anglong Transfer of Land Clause Act 1959. It is seen that in pursuance thereto, the impugned notices were issued. It has been submitted by Mr. J. Sutia, the learned counsel appearing on behalf of the Karbi Anglong Autonomous Council, that against the order of the executive member, an appeal lies before the executive committee.
56, earlier it is observed by this court.
Karbi Anglong Autonomous Council, of the executive committee of the Karbi Anglong Autonomous Council. And the same aspect is also reflected in the order dated 6/5/2023 passed in WPC number 4014/2011.
2013. 13.
Or 13. 6/5/2000. This court had heard the learned counsels appearing on behalf of the parties. And it is the opinion of this court that the notices which have been issued, impugned notices which have been issued, are results of the dismissal of the appeal being land appeal number 1/2019 date by the order dated 22/7/2020. It is also seen that the said notices have been issued in accordance with the provisions of section 5 of the Karbi Anglong bracket Transfer of Land Act 1959. Therefore, unless and until the order dated 22/7/2020 passed in land appeal case number 1/2019 is not interfered with, the impugned notices cannot be interfered with. Under such circumstances, this court is of the this court is of the opinion that the instant writ petition lacks merit without a challenge to the order dated 22/7/2020 passed in land appeal case number 1/2019. And as such, the instant writ petition stands dismissed. However, this court categorically observes that the dismissal of the instant writ petition shall not cause any prejudice to the petitioner to assail the order dated 22/7/2020 passed in land appeal case number 1/2019 in accordance with law. Yes.
By this situation, we have challenged the order of mutation dated 7/2/24.
We are challenging the order date.
7/2/24. Let me just point out one thing before I start. There is a caveat in the matter, but I have just produced the caveat. The caveat has been filed in respect of an entirely different order. So Lordship, is the caveat.
Anyway, you save yourself from the
Lordship, that
pain
is
of
there,
taking
I've just
steps.
pointed that out. Only that. Lordship will kindly see the impugned order.
What are you challenging?
Lordship, that is at page 55. 55, Lordship.
Regional land mutation information. Information. Is an information?
Mutation has been granted in favor of the other school in violation of the orders. Lordship, what had happened in the matter is, Lordship, earlier mutation was granted in favor of Moinaskin Memorial Academy. That was cancelled on Lordship, page 37, 27/6/2018, that was cancelled.
Oh, you are challenging which order? Tell me. Where is that order?
Lordship, page 55, Lordship.
Page
Page 55, Lordship.
55 is not an order. It's an information. This is an order.
Based on this one, Lordship,
Under whose occupation the land is. This is an information. Where is the order?
based on this one, Lordship, there is a title suit pending wherein they have now sought to amend that title suit saying that this is the mutation order. And accordingly, they have sought to amend the counterclaim in the title suit.
Fantastic. Whenever I sit in bench one, you tell me. But now tell me out here. This is not an order. You are challenging an order. Where is that order?
Based on this,
The base, Mr. Chakraborty may do anything. That's his lookout. But the question is, this is information. Where is the order you are challenging? How will this court know the reason?
the Lordship will kindly see one aspect. Lordship, only one thing, Lordship. The earlier notation and land occupation which was granted to them was cancelled. They came up before this honorable court. This honorable court directed them, if they are agreed, they should file an appeal. No appeal was filed, Lordship. Now, Lordship, this information, this page 55 information has been given. On that basis, Lordship, they have again went ahead that occupation of the land, those observations,
How the occupation being maintained school building?
paragraph 8, which Lordship will see,
How the applicant got occupation of the by right of purchase. So you have to get this order. Where is that
Your
order?
Lordship will kindly come to page 48 for a moment.
40,
48, Lordship.
48. Yes.
See down below, the last paragraph, if I may read it, Lordship. Also, the rectification deed number 57, 58, and 59. There. There.
Mr. Consul, I'm not concerned with that. You want to challenge the mutation order, challenge it wherever you feel like. But the fact that this is not a mutation order.
Lordship, the
You want to challenge the mutation order, challenge it. Where is the mutation order?
land mutation information has been given in violation of the order of HG 22. And this I got it,
Is
Lordship.
there any bar passed by this court that don't give the provisional land mutation information?
It was already cancelled, Lordship. That is what I,
Is there any bar in providing the information?
this information by this speaking
Let us
order,
see where there is the bar.
no, Lordship, this by this order,
Where is the bar for providing the information? We are concerned by a right to by the public information officer, not that order. Where is it?
page 48, last paragraph, you may just read it. Lordship.
Page?
Page 48. The last paragraph, if I may just read it for.
Page 48 is not this court's order. I'm not concerned with that. Show me this court's order. Where is the bar of providing the information?
Submit it to the Lordship. Page 48, this information which has been given in page 50 has been cancelled. They had challenged this order in WBC 251020.
Mr. Counsel, I don't understand. I have not been able to make you understand. You are challenging an order of 7/2/2024. Where is that order?
The provisional land. mutation-
You are saying that for bearing on authority from taking into consideration the mutation granted in favor of so and so by the impugn order bearing number dated 7/2/2024. Where is that order?
Seven-
And if you don't tell me that this is the order,
seven-
even Mr. D. Chakraborty will laugh. Good judge coming up on 21st of October before this court, taking up this bench. will move.
That is not my, that is not my intention.
Now, this is your headache because this is not your order. You are to come up with a certified copy of that order. Then only this court can look into it. Tell me. It's an information, Mr. Counsel. They may have done many things. The trial court may have allowed this. You see, this court had been all along practicing in the civil side also. So I know basically what is a mutation order. An information given by the PIO cannot be an mutation order.
So this one, Lordship, all the subsequent permissions have been granted. On the basis of this information, all subsequent permissions have been granted, and this permission is.
They are showing this. This is not a no. You want the clarification, I can say that. You make a submission that you will file another writ petition bringing on record. And I will say that this is not a mutation order. You get the declaration over, then you may do whatever may be. With that declaration, it may help you everywhere. And you challenge the mutation order. You were under the assumption that this is the mutation order. I think that will solve your problem. You can't say anything. He's withdrawing.
Sure, but if you could allow me to, I'll not say anything, but.
But what do you say? No, how can you say? No, but Mr. D. Chakraborty, can you say this to be a mutation?
It's absolutely spot on when your lordship observes that this is only an information. It's not a mutation order. But the fact remains that, well, for a while, assuming that this is a mutation order against which they have come before the, can they come before this order?
No, this is not a mutation order.
Otherwise,
He will come when they get some certified copy. He has come on a misapprehension that this is a mutation. This is merely an information. Mutation order, you get a certified copy, and then you can challenge them.
So far, our entitlement to a mutation order. is
Yes, I
concerned.
am not concerned.
These are things which will come in subsequent course of affairs. So far, the school's entitlement to a.
Mr.
mutation
Council,
order-
as of now, this is not a mutation. Let us end it. today. Mr. MP Sharma, no,
A Chakraborty.
A Chakraborty. Heard Mr. A Chakraborty, the learned counsel appearing on behalf of the petitioner. Mr. Miss So-and-so appears on behalf of the respondent number 1. Ms. So-and-so appears on behalf of the respondent number 2, 3, and 4. And Mr. D. Chakraborty appears on behalf of the respondent number 5 to 8.
My lord, I have the power for respond number 7. I can place it.
Appears on behalf of the respondent number 7. The petitioner herein have challenged the order number LCS dot 37/2023/268 dated 7/2/2024. On the basis, assuming that assuming that the said is a mutation order. Pusto. A perusal of the said document, which is enclosed as annexure A11. A11 at page 55 of the writ petition reveals that it is only a provisional land mutation information. And by no stretch of imagination can the said document be said to be a mutation order. The legal counsel for the petitioner therefore submits that he may be permitted to withdraw the instant writ petition and file if there is any actual mutation order. Taking into account the above, this court closes the instant writ petition on withdrawal with the observation that the document enclosed as annexure A11 to the writ petition is not a provisional land mutation, is not a mutation order, and it is merely a provisional land mutation information. Under such circumstances, the petitioner, there being a formal defect in the instant writ petition, the petitioner is permitted to withdraw the instant writ petition and liberty given to the petitioner to challenge the mutation order, if any, subject to the same being permissible under law.
He has at the very outset raised this caveat thing. I have this power. Can I place it? Let it be on the law.
Okay, no problem, it will be there. Yeah, put your name out there. You file it there. Yes, morning, I am not able to issue a notice. This
7.
item number. Yes,
Only password for timing yours. The senior is on lake on port number 1.
what are you asking?
Lordship, the petitioner being Chakma community and he has right as being a hill stripe plain community. So he filed an application before the Karbi Angalam Autonomous District Council for showing the allotment of forest land, which is allotted for the Chakma community or any hill stripe.
Then
Then
what is the information you are asking? Petition for information, what you are asking, purpose of the land allotment.
land was allotted before for us. How
Whether
many-
land has been allotted or not. Now, what information did you get?
After filing RTI, they As per order dated 6/3/2024, Annexure 9, Your Lordship. By this order, the second
Annexure?
appellate, Annexure 9, Your Lordship, page number 30.
Observe to dismay and despite still repeated warning in the air. So there is a direction to give you the information. Then what happened?
After that, they only give us reply that they receive an application. Only dates are given, but the relevant information is not given. Later on,
They are giving you the information. What are the information you are asking? Let us see.
page 32, Your Lordship.
Eight?
Page 32, Annexure 10.
No. Where you are in application is where? Yeah. Information sought for are number one. When did the petitioner receive? Petitions received in the office of the chief area. What is the diary number? Received petition on so and so, and for submission of his views and comments in this regard, copy enclosed. When did the petition placed in files before the honorable so and so? Does not arise, means it has not been placed. Supply clear copies of the records of file notings, same as one. Then where the state petition is referred to in so and so, forwarding sent to the department. Enclosed photocopy. Photocopy given?
No, my lord.
Photocopy?
My lord, I replied, my lord.
Now where is the photocopy to this? Page 32?
My lord, your lordship kindly see, my lord, page 34, paragraph number 2.
No, I am asking you, page 32, where is the photocopy? Why have you not enclosed the photocopy?
That photocopy, my lord, we have enclosed with the application address to, my lord.
No. Here he says number four is where the petitions referred to or transferred to any other departments. If yes, supply clear photocopy of the forwarding letters. Why you are not enclosing? File it properly.
The prince, my
The
lord, Annexure
petitioner,
10,
my
my lord, it was issued by the Principal Secretary, Karbi Anglong Autonomous Council.
My lord,
And lordship will look into the who are the parties. Karbi Anglong Autonomous Council itself is not a party. Principal Secretary is not a party. It's difficult to appear on behalf of.
Legal service. Legal service. Legal aid. What is legal aid doing on all these things?
my lord, this is RTI application filed before the public information officer, my lord, first of all. It was not, my lord, acted upon. Then, my lord.
So if
first
it is not acted upon, is there not a provision?
First appeal is done.
No. Is there not a, once there is an order being passed, if it is not acted upon, what is the consequence? Well, there is a specific provision, you can very well take it out there, that they have not provided me this information in spite of the order. There's a power of contempt which is there. Why you are not going there? In a similar petition, if you came, I dismissed it or something to that effect. There's another matter which came up.
My lord. Some other matters, my lord,
But-
regarding that.
But here, my lord, the.
I
facts
remember
are-
Yes, my
another
lord,
public
lordship passed the
information,
order.
huh?
Lordship issued notice in the doctor or some other persons
Ah.
here at the legal aid council regarding they sought the allotment of the land.
Ah,
Sakwa committee in
yes.
that area, my lord.
Yes.
Lordship had already issued notice in that particular case.
No,
But in this
no.
particular case against the RTI, my lord,
This is-
and lordship will look
this
into
is-
the party, my lord, page 4. Who is the
This
party?
is also,
This is
also-
matter on 21/10/2020.
this is also for allotment of forest land, my lord, as per the act, my lord, that I have indicated.
Where is the
The-
application?
the-
If you are to get your allotment, hide that. What are you doing with this? There are many applications which have been coming before this court with petitions whereby they have filed the applications, they have not been done, and we should notice in those respect. And thereby orders are being passed, not only in respect to Karbi Anglong everywhere, because these are all, because Chakma comes within the ambit of this.
My lord.
They are considered to be scheduled tribe for autonomous districts only. So therefore they are entitled or not, that is another thing. But another issue has been raised by Mr. Jesutia in another matter, wherein he says that whether they are citizens of India is another question. But then also you file those requisitions. What is this with this RTA and all? If you are a legal aid, give a proper legal aid.
My lord,
Mr. Sen, give a proper legal aid. Anyways,
I'll file.
file those type of petitions. That will be proper legal aid. Yes, Mr. Ghosh.
My lord, similar issue has already been cited, your lordship.
Where?
I have annexed the order. Kindly see page 16 is my representation and the order passed by your lordships at page 23.
Oh, this one.
Yes.
Then I asked you, why did you file that second one? Then you said that was filed at the time when your lordship did not pass that order. Isn't it the same thing? I initially passed an order. Then comes the second repetition within 3 or 4 days. Then I asked you why. Then you said that I already filed the petition. So in the second matter also I passed the
Yes,
order.
it's taken.
But now everything has been done. Now why?
Now, page 16, my lord, I have filed application by another person, two persons.
Now what happened? Your under such a this court inquired with Mr. S.K. Ghosh, the learned counsel appearing on behalf of the petitioner as to regard the representations which have been included in the 5 and 6 to the petition. In the second one? I remember.
Now, regarding representation, it is there. Representation is there in this. But
It appears to be type copies without
observation
revealing the
which has been
original
made by your
document
lordship,
for the matter.
that will help me. Because all are affected.
Now, in this case, you have submitted representations. So we do one thing, this is a representation.
It's
16/9/2000, we undersigned so and so, but it has been the development work of Bhilwara has been undertaken by the government continuing to tender for construction. Thereafter, tender has been finalized, contract is started. We will all know the construction will be Major representation. Huh?
Page 16.
Oh, that is what I read. Yes. Who appears for the PWD? How many petitioners? I think this, the second order will be proper.
Yes.
It will be disposed of for you. You dispose it off. Because I am not interfering with the construction any, yeah. What my order was passed earlier in respect to the same road itself.
Same road.
There's nothing to distinguish an iman, and with the said iman, the disposed of the incident can be entertained or not be entertained. That this court, however, observes that in the circumstance, the land of the petitioner is taken by the respondent authorities. The petitioner would always be at liberty to approach the concerned authority, and in that regard, the concerned authority shall duly take appropriate steps for redressal of the grievance of the petitioner. Okay? Yeah, dispose.
That is the request.
Yes.
Your Lordship, I'm appearing for the petitioners. There are two other related cases where the lead case is listed at serial number 1 of the tomorrow's cause list. So if it's requested, if all the three matters can be taken up together tomorrow.
So that tomorrow we have just passed a very short order that nothing survives. Now tell me what is the case about.
Your Lordship, I'm challenging the sanction of prosecution proceedings. So there was a belated deposit of TDS from my behalf. I have deposited the entire TDS along with the outstanding interest. What the income tax authorities have done is they have launched prosecution proceedings against me without considering one, the merits of the case, and the way I have also filed for compounding of the prosecution, which is provided under the provisions of the Act. They have rejected my application for compounding only on the ground that it is delayed. Now, the delay does not come from the provisions of the Act. CBDT had only issued a circular that it is preferable if the application for compounding should be filed within 36 months. I accept that the application was filed beyond the 36 months timeline. But the CBDT circular cannot go beyond the provisions of the Act. And this has been consistently allowed by various high courts that even if the compounding application is filed beyond the time prescribed by CBDT, it should be allowed on merits of the case. That
Where is the order?
Your Lordship, the order which is rejecting my application for compounding is at page 81, Annexure 7. It is just a 5-line order.
And your application was?
My application, Your Lordship, is at page
76.
page 75, Annexure 6.
What was the prayer? As to compounding the inadvertent default, if any, in the interest of justice, taking a lenient view. How much was the delay?
So, Your Lordship, the prosecution was launched in November of 2017, and the sanction for prosecution was given in January 2018. The complaint was filed in January 18. I have made all the deposit of outstanding demand and interest by March 2018.
Then?
And so, Your Lordship, as on the date when they filed the complaint, nothing survives. There is no loss to the exchequer. Whatever the delay and the fine was there, I have deposited everything. And this is also accepted by the department. Your Lordship, if you see the order which is rejecting my compounding application, there is an Annexure A at page 82.
And as per the provisions of the Act, what is the time limit was prescribed?
So, Your Lordship, there is no time limit prescribed under the provisions of Act. There is a provision allowing me to file an application for compounding. This time limit is only circumvented by way of a CBDT circular.
Okay.
And
But you have to then show a good cause, a reasonable cause. Why there was a delay?
Your Lordship, there was a delay. I filed a reply to the Income Tax Department with the compounding application laying out the reasons. There was COVID. There was ban on coal mining in Meghalaya, which was impacting my production directly. And
What is the breweries doing with the coal mining?
Your Lordship, the coal is used for production of extra neutral alcohol. So if the coal, there is non-availability of coal, my production is hampered.
Is it?
Also, your lordship, they have not rejected my application on merits. They have rejected it on a very technical ground.
Page
The
33 is the
issue is
reply.
also technical only.
Page 33 is the reply. That was showing sufficient cause, but that is not the one reason, because ban and ban on liquid shop as well.
How much is the delay?
More than the release, which is
Yes, how much is the delay? Beyond
Your-
36 months?
Your lordship, the delay is around 36 months approximately.
Here it says, application is required to be filed within 12 months. However, can relax up to 36 months. But how much is the delay?
So, your lordship, the delay is of 30 months because I filed my,
Beyond 36 months, another 30 months.
yes, your lordship. But at the time when they are launching the prosecution, my interest and penalty and demand was all paid off.
You have already paid it. That is why you are coming for compounding.
Yes, your lordship. And
Yes,
they have
everything.
accepted this position.
If you know the lordship is saying, and relying on one judgment of Honorable Supreme Court.
Ah.
If 1992 to CC page 672, paragraph 10. Just give you small paragraph. The explanation in the nature, the proviso 79(2) of the Act, with the result that the exercise of power by the commissioner under the said section has to be subject to the inspection issued by the board from time to time. The explanation empowers the board to issue orders, instructions, and directions for the proper compounding of the offence under section 279(2) of the Act. And further specifically provides a direction for obtaining previous approval of the board can be issued. Regarding section 279(2), come to the explanation, there is no manner of doubt that the commissioner has to exercise discretion under same section 279(2) of the Act in conformity with the instruction issued by the board from time. This application was rejected.
But how does this ban or anything have anything to do with filing of the application late? Madam, how does this
Yes.
ban have a correlation with the application?
So, one that your lordship, I had the complaint was
You
filed in
have paid the money. You have
yes,
already paid. You paid
yes,
the money long time back.
yes,
You paid the money deposited after 1 year, 24 months.
Yes.
24 months.
yes.
Yeah, after a gap of 1 to 24 months, you have made the payment. So meaning thereby some are 1 month or whatever may be, you did not deposit the tax, the TDS which were deducted within time. So this is about 24 months there was a delay. And these are all cases of 2015-16.
Yeah, so your lordship, there are 3 cases. 2 are listed tomorrow.
All these things at the time, even when there was no COVID.
Yes, your lordship. COVID came in 2020.
So COVID did not come. So thereafter, how does the filing of your application for compounding is done after the period of 36 months, 30 months after from the 36 months, permissible 36 months?
So,
For filing the application for COVID, compounding, you don't require to deposit anything.
no, your lordship, I'm required to first make the entire payment. If nothing survives, only then compounding.
You have
will-
already paid 24
Yes,
months
your
back.
yes, your lordship.
Already paid within 24 months of the ending of the financial year 2015-16. So 24 months, it is okay, but I think by 2017-18, you must have paid it. COVID came in 2020, 20 to 22, it is okay, acceptable. But how do you take care that you filed only on 4/8/2023? Even the Supreme Court, the directions were passed to that you could have filed within 90 days from 28 to 2022. How do you take care of that situation?
So,
We'll hear you tomorrow.
obliged,
Notice
your lordship.
number 1, 2, and 3.
1 and 2.
1 and 2. The last day of the our court. I hope I don't dismiss it, 3 of the matters together. Can you list this matter tomorrow at 2 p.m.? We'll have it at 2 p.m.
Obliged, your lordship.
along with and by the SLC is set aside in court. The petitioner herein have been able to substantiate the criteria laid down in Ramesh Bhai to the extent of proving that the petitioner number 1 have been under the care and custody of the petitioner number 2. The petitioner have been able to prove that the petitioner number 1 as well as her brother did not get any advantage on being an offspring of an OBC father. The petitioner number 1 as well as her brother have been raised in the community of her mother, have automatically suffered the deprivations, indignities, humiliations, and handicaps having been brought up in the community of the mother since their nascent age. The petitioners have been able to prove that the community of the mother have accepted and have identified them belonging to the community of the petitioner number 2. However, the aspect as to whether the petitioner number 1 as well as her brother has been accepted by the other people as belonging to the ST community of the mother is not clear from the records. The reason being that the inquiry officer, while submitting the vigilance report, did not take into consideration the relevant aspects while purportedly making an inquiry with the person of the locality wherein the petition number 1 and her brother have been raised. It is also seen that had the vigilance report been furnished to the petitioner, they could have provided necessary evidence in respect to prove the said aspect as to whether the other people, apart from the community of the mother, had identified the petitioner number 1 and her child as belonging to the petitioner number 2's community. Under such circumstances, this court is of the opinion that the matter requires to be remanded back to the SLEC to decide only on the aspect as to whether the other people belonging to the petitioner number 2's community, as to whether the people belonging to the community, other people other than the people belonging to the community have identified the petitioner number 1 as well as the brother as belonging to the petitioner number 2's community. This court further grants liberty to the SLEC to call for another fresh report on the above aspect which have been directed to be considered. That is, as to whether the other people of the locality have identified the petition number 1 as well as a brother as belonging to the community of the petition number 2. Upon such report being furnished, and if such report goes against the petitioners be provided with such report and given an opportunity to adduce evidence as well as an opportunity of hearing. With the above observations, the incident with petitions and disposed, the records which you have produced is hereby written. There's some corrections here and there. You take
Yeah.
that record to be moved forward.
In this matter, we received instruction where the chief engineer continuously has been asking for a fund demand from the executive engineer also. The executive engineer is now submitting a fund demand, but not proper format, your lordship. But it's, I will this is letter, your lordship.
Go, this is good. Who has not done it?
It has not submitted.
What to do? No, the reason is if the chief engineer does not have the control over the executive engineer,
that they are not trying to able to trace out this computer records which is needed to be filled up in the format you're launching.
Huh?
The executive engineer is now stating that they are not being able to trace out due to due to shifting of the office many times. They are not being able to trace out this administrative approval technical sanction report you're launching. That's a standard executive engineer launching. So the chief engineer has already communicated lots of times, submit a fund demand proposal in a proper format you're launching.
How much does the petitioner have to get? No, I have issued a contempt notice against you. So. This won't do.
That is complete the executive engineer now. It's not a party because the chief engineer is just a forwarding authority.
Isn't it the sorry state of affairs that the chief engineer does not have the control over the executive engineer?
They have, that's why they repeat time and time they're asking for this for, because she's asking for a fund given proper format. He's not saying the fund given a proper format, your lordship. Various communications have been made, your lordship. That letter which I have submitted, the references are there, lordship.
So he has to pay now how much? 4,25,000 to whoever. Get it from somewhere and pay him. That is your lookout. If you are not, your officer is not in control of it, can't help it. Or is the secretary to the government of Assam creating the problem?
Big problem, lordship. The problem is starting from the root, from the executive, from the division level, lordship.
You're not concerned. Not satisfied with this. Affidavit file. I will ask her to be present and we'll ask her to be sent to.
That the executive engineer come and explain, lordship, the reason
No,
why he is
not necessary. If you don't have the control, there's a direction only to the chief engineer.
But-
When the chief engineer have been directed out there, the chief engineer has to do it.
chief engineer.
That tomorrow you may say that the peon out there of the chief engineer is not forwarding the AI and the chief engineer doesn't have the control. You may say that.
No, lordship.
The PhD department can go to that extent.
Chief engineer time and again has been asking the executive engineer to submit a demand, your lordship.
I
Well-
don't understand how the executive engineer is not listening. Isn't it a
Executive-
case of insubordination?
Yes, he's submitting the documents, your lordship, but not the proper format, your lordship.
I-
Now the executive engineer.
Doesn't he understand English or any language?
Now he is stating that they are not being able to trace, some columns could not be filled up in the format due to, because they are not being able to trace out the record. The executive engineer has directed them to send
So
them,
tomorrow they may say that we are not in a position to trace out, so matter ends. We won't pay. Can it
they
happen?
have to trace it out, your lordship, because the works has been done, they have to do administrative.
Well,
your lordship.
if that be so, then why not?
Because the chief engineer is a forwarding authority to the higher authority for a payment of the funds, your lordship.
Mr. R.R. Gogoi, I give you time till 4/11. Pay the amount, whatever it is. If you don't, then ask the person to be there. I mean, I'm not satisfied with this thing, then we'll pass orders.
Very good.
We have already initiated contempt proceedings out there. Contempt proceedings will follow. And as to why she should not be punished, pass the order.
Very
I give you time till 4/11.
Well.
Mr. R.R. Gogoi, appearing on behalf of the respondent, submits that that the respondent have been have been taking steps with the executive engineer, concerned executive engineer, under whose jurisdiction the work was done. And on account of certain documents being not placed, the respondent is not in a position to further proceed as regards proceed with the necessary sanction. This court is of the opinion that the respondent is an opinion that the fact that the amount of rupees 4,25,000 286 is an admitted amount by the respondent authorities. And this aspect of the matter have also been admitted in the affidavit filed by the respondent. Pusto. Under such circumstances, it is inconceivable as to why there has been these bottlenecks created by the officials in not releasing the funds to the petitioner, the entitlement to the petitioner. Accordingly, this court fixed the matter on 6/11/2024, providing a final opportunity to the respondents to take appropriate steps so that the disbursal of the amount is made of the petitioner's entitlement is made on or before the next stage. This recording.
Item 48.
Yes, Mr. Bidugwan.
We have restructured this petition to give it a new look for the social boycott case. And I have annexed the Maharashtra ordinance as well as the Maharashtra Act, as well as the proposed bill. A bill was placed, but it was not passed, and surprisingly in the new BNS that has not been taken care of. In two judgment, I have found out Odisha and the Calcutta High Court. Odisha High Court is conscious of the fact that the court cannot order for legislation, but the state should take care to say that this social boycott which has been inflicted on those petitioners should not be continued. And in another case also, but your lordship, the similar line that they have given some guidelines. So today, so far in one of the judgment, I find of all those are of the High Court, of course. This says that so far social boycott is concerned, the IPC offenses are not capable of dealing with it. So that's why probably this new bill has come. So, but a person cannot be without remedy. This since it is a violation of Article 14 and 21, and to some extent of Article 15 and 17.
Why are you making these people a party 6 to 12?
Well, they are the people who have who are like acting like Talibani and posing this social boycott on us.
What is this word Taliban?
Hairs and all who
Is that a phrase in the dictionary of in English?
now many words have come.
It is something
But-
like something like the social boycott legislation will also come in.
Yes, these are the cases, Malad, which are not come on day-to-day basis. Just like all the three
It's
cases.
only when Mr. B.D. Kumar appears.
Malad, these are some of the issues, Malad, which your lordship has also.
Anyway, because why I'm saying, because the issue involved out here is to that effect as to whether there should be a law.
Yes.
In absence of a law, what is to be done in respect to a social boycott? That's the issue.
Yes, yes. And your lordship can apply to that again, that doctrine of parents patriarch. When they
No,
state that.
not here. But then also unnecessary why you are making these people a party.
Malad, they are the people who have been.
They may have done, but in the bigger picture of it, what did these people have to do? Because this court can't issue a writ to them.
Your lordship, let them remember, your lordship may not ask us to take steps on them. Let them, because some.
We
Again,
won't issue notice.
yes. Let first hear the state, Malad, what the state has to do. Because this will have far-reaching impacts over the state of Assam is concerned.
Notice making it returnable on 4/12/2020. Mr. A. Sharma appears on behalf of the respondent number 1, 2, 3, 4, and 5. For the present, this court is not inclined to issue notice upon the private respondents. Pusta. As the respondent numbers 1 to 5 are duly represented, extra copies of the petition be served upon them during the course of the during the course of the day. Pusta. Upon Mr. H. Sharma during the course of the day. Pusta. The case of the petitioners herein that the petitioners are victims of social boycott by the various by social boycott by the private respondents. And in that regard, the petitioners have represented before the District Commissioner Kamrup Amingao for redressal. Mr. BD the Learned Senior Counsel, appearing on behalf of the petitioner, submits that the problem arises on account of there being no specific legislation either framed by the central government, either framed by the union or by the state of Assam as regards protection of people from social boycott and what prevention and how prevention from a prohibition and redressal can be meted out. He therefore submitted that in Maharashtra there is a legislation to that effect. The Learned Counsel, Senior Counsel further submitted that in various other states where there is no such legislation, the court, taking into account the fundamental right enshrined under Article 15 of the Constitution, have also formulated certain guidelines. The petitioner herein, therefore, seeks appropriate guidelines to be formulated till appropriate legislations are made in that regard. The respondents are directed to bring on record their stand by filing an affidavit in respect to the case, in respect to the bring on record their stand by filing an affidavit on or before the next date.
49.
Yes, Mr. Ahmed. What is this?
What we are going to a bit.
Where?
It is Sunapur circle and the village is Sunapur Pathar.
Huh?
Sunapur Pathar.
What right you have?
Actually we have no rights.
Huh?
Actually we have no right because
They are all
tribal well. That is, but only lawsuit has said this was some petition on page 98. On the light of that observing that petition will be discussed since we are not evicted fully. And they are going to be evicted. As per your lawsuit judgment, the petition is to be disputed. We can submit our representation before the district authority. They would consider the case maybe.
This is not the case. This is not the judgment we should be relying on.
Page
It's
98.
another case.
Page 98. It is Kosotoli, area. And our village is Sunapur Pathar.
Notice issued. We are not the owners of the land. but you have acquired derivative rights. তো order করে দিব, next dispose of করে দিব, no? 311 of us. নাম কিটা বদলাই দিব, জে আহমেদ, এইটো বি বৰ, আর বৰ পূজাৰী হলেন বি আর মহন্ত। 26/9. And you submit your,
In 15 days, sir.
what?
Within 15 days.
7 days, no 15 days. Huh? 15 days. When was this moved? 26/9. I gave time till when? 4/10. Then 26, 4 days and 4 days, 8 days. I'll make it 6. You have no right.
My lord.
File your thing on or before. The office is closed when? Where is the DC office is closing when?
13, 17.
No, don't come up with the High Court. I think the puja is from 10th. The government DC office is closed till when? 9? No, not 9, 10. 10th is the puja. 10. আপোনালোকৰ বন্ধ কেতিয়া পৰা? DC office closed till? I think you are reopening on 14th, na, DC office? No, then it will depend on that, na, because if it is on 9th, I have to give them time till 14th. But if it is on 10th, I can give them time till 10th. But I think 10th, the DC office may be open or closed. Anyway, find it out. Let me know. It will be either 10th or 14th. Let's make it on 14th. Let them file it by 14th.
Fine.
Anyway, they are going to go. Okay. Huh? Yes, what is this?
The change, so senior counsel is appearing on the.
Well,
Next in court number 1.
Impugn order passed by the Borpeta, thereby allowing the private respond number 6 to collect the land revenue of the Borpeta town for the time being. Who is respond number 6?
Private response. Was that a?
26/9/2024. 6/9. Falls under the Gaubura Muga and the same is
Your lordship come
also
to page-
mapped according to the right tree, therefore for convenience, Srimati Meena Pratap within the area. Yeah, what is your problem?
What timing?
Timing.
Page 42.
Yes, I'm ready.
Because of that, Lord. Because of that, Lord.
No, why is the petition agreed?
The petitioner was earlier taking that Khazna lordship, the land area. That's because if your lordship comes to page number 39, this will clarify. Second paragraph, lordship, secondly, it has been noted from the letter under reference that although Borpeta Road Town falls under Ubodhana Muza, the task of revenue collection and record maintenance has been carried out by the Muzadar of Hauli Muza. However, it has not been clearly stated when and by which authority the decision to allow revenue collection by Muzadars of Hauli Muza to Borpeta Road Town. Borpeta Road Town falls under the Ubodhana Muza according to this order was passed. Earlier it was collected by Hauli, Muzadar of Hauli. And the present petitioner is the Muzadar of Hauli. As because it was that power was curtailed from that Howley to, and it was given to the Govardhana Lordship, that is right.
Last item of the day.
That's okay. I have to wait. I have not to wait.
Eh?
I have to wait till 4. Okay.
Yes, what is it?
May I please as your lordship? Lord, Lord, I am sick. Apology, my lord, due to my illness, my lord. I have to appear virtually, my lord.
Ah.
My lord, a similar petition, my lord, regarding that eviction at Kotsukoli and my lord, that Sonapur Pathar. My lordship has few days back has disposed of a similar petition, my lord.
Belong
My
to
col-
which category?
My lord, that category belongs to my lord, power of attorney holder as well as my lord, the sale deed holder, my lord, derivative rights, my lord.
Power of attorney and derivative title.
My lord, my lord,
Sale deed.
Like that, Lordship, I
My-
can 49.
Same
my
order.
lord.
How many petitioners are here?
30. Please understand. Petition.
DC office will be closed from 10 o'clock.
But Mr. Counsel, you see, recently I could see that the Supreme Court have yesterday, yes, have already reserved the judgment in respect to laying certain guidelines for all
Well,
authorities to take action.
Bulldozing, my lord.
Yes, but then also the Supreme Court is of the opinion of giving, providing in all states and area that certain guidelines. And I'm told that the Supreme Court had also directed certain stay in respect to these evictions, isn't it?
My lord, a contempt petition had been moved, my lord,
Yes.
before the honorable, my lord, my lord, in that contempt petition, the honorable apex court was pleased to issue notice. And in the meantime, my lord, status quo has been directed to be maintained amongst the parties, my lord.
Now, if that be so,
My lord.
what remains? Why
My lord,
the directions are required?
because my lord, the amongst the parties means my lord, those persons who has approached the Supreme Court only, my lord, that if
I don't think
may
so.
My lord,
You have the order. Anybody has that order? Contempt order?
Lord, we can furnish it, my lord, for some time, my lord.
Give that order because that is a relevant thing. Why I'm
Yes,
saying
yes,
till the next
my
day,
lord.
direct that there shall be no any way to country without seeking the leave.
My lord.
This is in respect of another aspect. But why I'm saying so is
My
why
lord.
this, why don't the states stay for their proceedings? Because there is already an order passed by the Supreme Court in that regard. And more particularly in respect to the Hunapur case, the matter contempt was filed. And in that contempt was categorically directed in respect to the Hunapur evictions. And if
My
that be
lord.
so, then why everything is not being stalled?
Because, my lord, still people are apprehending that they may be evicted because red
It is a
color
different
sticker.
thing. Another thing.
My lord. My lord.
Why I'm saying so, another thing is there. Yes, those people who have been already evicted,
My lord.
they can also come before this court to that effect to file appropriate applications.
My lord.
Yeah, that is another aspect which needs also to be taken into consideration as to, yes, they may be evicted. Because there are two aspects. One is eviction and the other is demolition. which
Demolition has been
we are
done, my lord.
dealing with. The moment the demolition happens, means it goes beyond beyond the purview. And if it's a eviction is there, it's okay. Then also you have the house remaining. But if the house is demolished, you can't get it back thereafter. It is very important.
My lord.
In fact,
My
that's
lord.
what was dealing with this aspect.
My lord, this is the last petition on my behalf, my lord,
No,
before the
no,
vacation. ma'am.
You can very well come up.
My
But the only thing I'm therefore, why should the state, in spite of various orders being passed, the Supreme Court also have passed, to continue to go ahead with further demolition or eviction?
My
That
lord.
is when the matter is pending before the Supreme Court also under contempt. No, we go by the other order, Mr. Mr. Bhuya.
My lord, my lord.
By this other order,
Other order, my lord, my colleague is holding the exact similar order, my lord, if he
that
may
is
be
the
permitted.
proper order.
Better,
where you
proper
have
order, yes.
derivative
Yes,
title,
yes.
na?
My lord, what has happened in this petition, we have specifically mentioned, last time I have committed a mistake, my lord. But the specifically I did not mention. In paragraph 3, I have stated in details, my lord.
Yeah, I think this, this order would categorically show,
My
subject to the petitioner showing before the district administration, or for that matter, the officials of the district administration, Kamrup Metro, that they are the petitioners to the instant writ petition, along with some documents to correlate the petitioner's possession over the land under the occupation. I think this
My
will
lord.
adequately protect you.
My lord.
Okay, it will order for you. Hey, আগৰ টো নিচিনাই হ'ব, disposed.
Oblige, my lord.
And they will submit their documents by 6 or 14, Lordship.
Oh, well, when please?
It will be closed from 10.
So, you submit your documents by 14th, huh?
My lord, my lord.
In the other case also 14th.
Oblige, my lord. Highly obliged, my lord.
11 order no step.
Yes, Mr. MJ Burwa.
Contact with me. I think they got relief when I want to contact. So there are steps, my lord, the independent body, the commissioner, they have not taken for that. So Lordship, they have not clearly instructed me also to withdraw the case. At this stage, my lord,
What steps you have not taken?
taken steps but not registered for Gosaigaon Town Committee is an independent body, so there is direction.
No steps have been taken by the reserve for service of notice upon the respondent, hence the matter is closed. Mr. MJ Burwa, the learned counsel appearing on behalf of the petitioner, submits that he has no instructions from his clients to stop. Be it as it may, the same does not absolve the petitioners from taking steps as directed by this court to stop. This court therefore directs the petitioner to take steps upon the respondent number 6 by way of registered post on or before 7th of October 2024, failing which the matter be placed before this court again. Take your instructions if you want to withdraw.
Item 12 for admission.
Yes, what has happened? Mr. BJ Talukdar, what has happened? What? Whether he has got the money or not, that is only the case. There is already a direction being passed by the Lower Assam, Commissioner Lower Assam Division, I think under 3G5. So whether you have complied with it or not, I think the competent authority therefore has to reassess, recalculate on the basis of the award. Good stuff. Mr. BJ Talukdar, the learned counsel appearing on behalf of the petitioner, a respondent, including the competent authority, seeks for some time to get up-to-date instructions in the matter. It is seen that the instant writ petition has been pending since 2017. And there has been no instructions placed before this court by the respondent authorities, Accordingly, this court fixes this matter on 11th of November, on which date Mr. B.J. Talukdar, learned additional senior government advocate, shall produce the instruction as to whether the order dated 4/1/2023 passed in case number RR 23/2012 by the Commissioner, Lower Assam Division, have been given effect to. That's all. Simple construction. Yes.
My lord, Krishna, before lordship are petty businessmen, my lord, they are running their business by making shops, my lord, over, my lord, PW room, my lord. But the circle officer,
The
by,
petitioner to
lord,
vacate
they-
the respective land within 5 days. Which one? Notice
notice, my lord, page 25,
25?
20, yes, my lord.
Notice,
sorry, sorry.
disposition notice. Village going to Zonia.
27, 28, 29.
Occupied the land mentioned in this. No dark numbers.
No, my lord.
Mr. B.J. Talukdar, we set aside this notice. There has to be, the notice has to be specific.
Yes, no,
Nothing is there. Where is the dark number? It has to be in respect to some dark number, nothing. No, heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Mr. B.J. Talukdar, the learned counsel learned additional senior government advocate, appears on behalf of the respondent number 2 and 3. Mr. PWD, you are not there, madam. No PWD. Yes, PWD. So-and-so appears for respondent number 1. The petitioners herein have assailed the notice dated 14/1/2017 in dispossession case number 08/2017, whereby the circle officer, Bagbor's circle office, Mandia, had directed the petitioners to vacate and leave the possession of the land within a period of 5 days from the receipt of the said notice. It is seen that pursuant to the filing of the instant writ petition, this court had issued notice on 10/2/2017, and there is an interim order passed to the effect that the petitioners may not be evicted. However, in spite of that, the respondents have not produced before this court any instructions or filed any affidavit in that regard in support of the said notice. This court have also heard the learned counsel appearing on behalf of the petitioner as well as the respondents, and have given their anxious consideration to the relevant submissions. A perusal of the impugned notice dated 14/1/2017 passed in dispossession case number 8/2017 shows prima facie, and it appears to be a notice without any particulars. Inasmuch as there is no mention of any dark number or any schedule or dark number wherein thereby identify the land in respect to the said notice. What has been mentioned in the said notice is the name of the village and the moja. In the opinion of this court, such vague notice cannot be made a basis in terms with Rule 18 of the settlement rules framed under the Assam Land and Revenue Regulations 1886. Accordingly, the impugned notice dated 14/1/2017 passed in dispossession case number 8/2017 is set aside and quashed. Repeated as it may, accordingly, the writ petition stands allowed. Before parting with the record, this court, however, observes that the setting aside of the notice dated 14/1/2017 in dispossession case number 8/2017 shall not preclude the Circle Officer Bagbor Revenue Circle to issue fresh notice giving due particulars and following the law as laid down by the division bench of this court in the case of Salahuddin versus State of Assam, Mohammed Salahuddin versus State of Assam, recently reported over GLT at 2024 for GLT. Page that. Very good. All equal to Asino 2024 SCC online 1086. Oh, not before me. Listed before any other bench without. Yes, Mr. Sheikh. What is this?
I have a limited prayer matter.
Limited?
Our village is surveyed 93. A similar village matter patta has been issued, but in our village, though we are landless people, my lord, patta is not issued.
Why?
Your lordship will be pleased to turn to page 28 is my prayer.
Have you got the settlement?
No.
Allotment?
Not allotment, no allotment. We are landless people, my lord. Around 74, we are residing on their land. Survey was done.
You have applied
My lord, we have applied.
before?
My lord,
You have applied?
yes, my lord. Your lordship will turn to page 71.
Oh, forest is there.
No, my lord, our land does not cover forest area.
Then,
My lord,
yes, why no instructions?
the notice was issued, my lord, on 6/5/2020.
The petitioner heard Mr. M. A. Sheikh, the learned counsel appearing on behalf of the petitioner, and Mr. B.J. Talukdar, the learned petitioner and senior government advocate appearing on behalf of the district administration. I've also heard Ms. D. Azoika appearing on behalf of the revenue department. The petitioner hearing are agreed by the non-issuance of patta. In spite of the fact that the petitioners have duly applied for settlement. The respondents are directed to place before this court instructions as to what has happened to the application so filed by the petitioner seeking allotment of the land. And as to any decisions have been taken. List this matter again on 25th of November 2024, on which date the respondents shall obtain the instructions without fail. Madam, your duty. Okay, none appears on behalf of the petitioner on call. Good stuff. The respondents are all, who is appearing? Okay, the respond, who you are then? What is happening? Good stuff. The respondents also, the respondent in the PNRD department have also not obtained an instructions accordingly list this matter on 9th of December 2024, on which date Ms. Enbora, the Standing Council of the PNRD, shall obtain instruction placed before this court the instructions.
17.
Settle then.
Yes.
No instructions. The council appearing on behalf of the respondents submits that there is no instructions. The petitioner is aggrieved by the non-issuance of the non-granting of the settlement of land in their favor. List this matter again on 29th of November 2024. In the meantime, the respondents shall obtain instruction. Respondents both in the revenue department as well as the district administration shall obtain instructions as regards the applications filed for settlement by the petitioner. Ex gratia, nobody is appearing. What is this ex gratia? Police inquiry? Tata track, okay. এইটো দি dismiss কৰি দিব। Non appears for a petition, সেইটো এটা judgment এটা আছিল নহয়। তেওঁলোকক সুধিলে পাব। মই follow কৰি দি দিছো, Justice Surana's judgment. You have an order to dismiss কৰি দিব। Taking into account, none appears on behalf of the petitioner on call, full stop. Miss D. Hazarika appears on behalf of the Revenue and Disaster Management Department, full stop. The learned counsel submits that taking account from the documents that the petitioner was hit by a vehicle bearing registration number AS07C 5327, the petitioner is not entitled to the benefit of ex gratia in terms with the notification dated 15/11/2014. The learned counsel appearing on behalf of the Revenue Department further placed before this court an order of the coordinate bench passed in so and so, wherein it has been categorically mentioned that there would be no, that the benefit under the notification dated 15/11/2014 would not be available in respect to such claims wherein the vehicle which had caused the accident have been identified. First of all, taking into account the above, nothing remains. Taking into account the above and the judgment passed by the coordinate bench, the instant petitions stands dismissed.
The number is Lordship 2700.
Name.
Manisha Khatun.
Manisha Khatun versus State of Assam, dated of the coordinate bench dated.
They have the soft copy, Lordship, date is not realized.
It is not there in the
2024.
dated so and so in Manisha Khatun versus State of Assam. Yes, who is there? What is this?
These are not payment of contractual deals. There are two similar
Contractual deals from whom?
from the state, but then the project was
Depends for matter.
projects were actually for the Ministry of Jal Shakti.
Ministry of?
Jal Shakti and Jal Shakti.
Oh, have you made the Jal Shakti a party?
My lord, in the other cases now.
No, without making them, it is not possible. Mr. B. Pathak, the Learned Council appearing on behalf of the petitioner submits that taking into account that the work undertaken by the petitioner is in connection with a of scheme of the government of India, more particularly Ministry of Jal Shakti and Jal Shakti. So he submits that he would like to file an appropriate application seeking to make the Ministry of Jal Shakti, Government of India as a party to the instance. List the matter upon filing of such application. Because later on it becomes a big problem and Mr. C. Sharma is expert in filing review. Yes, who appears for whom? R.S. Mishra, what is wrong with you? They applied for certified copy agreement, the previous Surya is not. None appears on behalf of the petitioner on call, full stop. Taking into account the grievance espoused in the instant petition, it seems that the petitioner have lost interest in the instant proceedings. Accordingly, the petition stands dismissed on anticipation.
Item 27.
What will your stand, the respondent? Number 3. When was this land taken?
Here, in this case, my senior will appear.
Who?
D. Mazumdar.
Okay, none appears on behalf of the petitioner on call. This is the matter of publications.
28.
Oh, this one,
My lord,
money.
my lord, the instructions as I get it, my lord, says that the finance and the ZAP has now released the money to the deputy commissioner. The deputy
DDO, my
commissioner,
lord, the direction may be given to the
deputy commissioner now to disburse it, my lord.
it's already been given. This is the latest one. The big Gogoi has delivered.
So, did you know why we are not paying?
Deputy Commissioner.
Deputy Commissioner?
Because the disbursement ultimately takes place
Yes,
from the deputy.
from the DC's office. Disbursement authority to the deputy. District commissioner. Mainly,
We are taking the last item anyways, that matter. Getting instructions. Today,
28.
this item. Just take the instruction because the money has been paid. When are you going to get? Because with that, I'll close this petition. Unnecessary this petition. Let him have a happy puja.
59.
Yes, what is this?
What's in this case, the petitioner executed one sale deed. That was after execution of the said sale deed that was not handed over to the petitioner.
Then,
In the year 2022, on 28 November 2022, sale deed was executed by the petitioner. On the Kamrup Rural Senior Sub Registrar. But same was not delivered to the petitioner lordship. Petitioner paid the stamp duty and registration fees, all the formalities were completed. And after execution of that sale deed, in the month of November 2022, the sale deed was executed on commission.
where is the NOC?
At the relevant point of time, the NOC was not applicable. The SOP come later on. Kindly peruse the affidavit.
This is of 2022. We are concerned about 2022. When did you execute the deed of sale? When did you execute the deed of sale?
2022.
The 2022, section 21A of the Assam, of the Registration Act was there. Where is the NOC from from the, what do you call it, district administration?
The relevant point of time that was relaxed.
No, it was never relaxed. Section 21A had never been relaxed. That is the issue which they are bringing in.
No, thereafter one.
You see, NOC for construction occupancy certificate, yeah. What is this? After going to the sale deed of the Iman, they found that the registration fees challan, NOC for construction, value of the Iman. What did you purchase?
So.
Huh?
Net. Soap area.
The shop, there was no value. Then why you are not giving it?
Lordship, we have filed our affidavit in paragraph 5, Lordship. Certain documents, Lordship, which are required. Those were not supplied by.
Oh, this one, I have taken it. How is it possible you do this? You can't come up with this NOC, this notification.
Our
This is
affidavit,
in violation to the Abdul Aziz judgment. Till you don't get the presidential notification, can you do that?
in our affidavit, Lordship, your Lordship has gone to that SOP.
Yeah, therefore, by way of an SAP, can you
Yes.
do that?
If it is already there in a act, Lordship, I think.
Act has been brought in because of the fact of that one, what you call, section 21A was brought in. Section 21A was brought in view of the Abdul Aziz judgment. Abdul Aziz judgment, after that, you come up with these, you say that executive instructions. But the fact that you have not received the presidential assent, because this will require presidential assent, because it is a central amendment to be made. You have not received 2022 till now. How can you do it? These SOPs cannot remain like this. What has happened till now? Get your instructions, or else it is a fit case for setting aside. Why you're not filing a reply? Mr. S. Agarwal, Mr. H. Sharma shall obtain instruction as to whether the amendment which have been sought for in to section 21A, whether the presidential assent in respect to the further amendment to section 21A have been granted or not. Because in the meantime, the petitioner would be at liberty to file the reply. This matter again on 20/11/2024.
Item number 27 lordship. So I was reviewing another code. So I started-
27. What happened? What order did I pass? Up to begin.
See, Manoj, we had applied for reclassification of the land. As per section 5(6) of the Reclassification Act 2015, the premium was filed out depositor. Thereafter, a NOC is required to be issued by the Deputy Commissioner under section 5(6). So that was not issued. Now, my lord, we have received an affidavit from the circle officer saying that the matter is, the land is actually falling in a eco-sensitive zone. And therefore, they are consulting the thing with the forest department. That seems to be an instruction that is annexed to
Lordship,
the
I
affidavit.
think up to date instructions will be required, as because this letter is on dated 17/8.
It is of 23, it is of 23.
The last line, though.
You have paid in principle approval granted?
And the premium was thereafter paid, my lord.
Premium also made.
Yes, my lord. Annexa 4 and Annexa 5 is the credit certificate.
Then as per 6, as per section 6, with effect from the date of commencement, every being found with every invalid. So once the payment has been made, how can you stop it?
Subsection 7, my lord, the NOC is to be issued by the DC. Then it goes to the revenue who makes a correction in the revenue record as to the category. Is 38, my lord, my petition. The relevant provision. That the owner shall furnish the receipt of salon of payment of reclassification premium at the rate as specified under section 6. To the DC, one being satisfied, shall issue a NOC in turn for reclassification come transfer. As far as eco-sensitive zone is concerned, we are also sensitive about it, my lord, but then that might be an issue about my future or use of the land. Because certain.
No objection certificate has not been issued.
No.
How is the relevance with the eco-sensitive thing? Eco-sensitive doesn't have any impact on that.
PS 26, what you could see, that the forest department already given a report. The land is in between Pratiksha Nursing Home, Maharishi High School, Tata Godown and Lime Factory. So it is surrounded by commercial land and therefore it is no longer anyways in agriculture.
Why they are bringing in the Amsang River?
But eco-sensitive,
It's outside the boundary of Amsang.
it's outside boundary of Amsang, but then 1 kilometer is a eco-sensitive zone, my lord, where certain activities like heavy industries and heavy commercial activities are prohibited. So So if I tomorrow, my lord, after reclassification, if I go in for a activity that is prohibited, then another law will come and prohibit me. Not this reclassification act. Under the reclassification act, once the assessments are made and all interdepartmental NOCs are obtained and the premium is paid, the deputy commissioner is to reclassify the land.
No, the deputy commissioner is only to look into the circle officer's report as well as the BLC report and then to do the action.
That is a lot, because this annexure, which we have annexed, that is of 17/8/23. Let me get that.
Mr. H. Sharma submits that he would like to take further instructions pursuant to the affidavit so filed by the circle officer, Chandrapur Revenue Circle, dated 27/9/2000, wherein communication dated 17/8/2023 have been enclosed. This matter again on 18th of November 2000.
It's fixed on 15th or 18th.
18th.
31. Your government affidavit, my lord, particularly at paragraph 137. I think you're not able to the case.
Yes.
37. It is seen from the above that it is a clear case of cold-blooded murder and it is not an action which was taken while discharging government duty. And
Regarding the
prosecution sanction under section is not required in this case. So they are accepting it's not on official duty. And second is, my lord, with regard to the statement made in so the deponent said that in this regard, a letter was received from the DGP Assam asking CID to examine the representation submitted by Srimati Joyanta Hoja regarding appointment of special public prosecutor and to submit our views. Accordingly, views submitted through e-office dated so and so of this office stating that the special public prosecutor may be appointed to conduct a trial of police station case. In view of this, you'll also close the matter.
But Mr. B.D. Das, the
Government
Learned
provide-
Senior Counsel appearing
Provide
on
the
behalf of
assistance of a public prosecutor at the earliest.
the
Trial is going on.
petitioner in the instant, assisted by so and so. It shall not be. The instant petition has been filed seeking appropriate directions from the court for appointment of a special public prosecutor under section 24(8) of the Code of Criminal Procedure 1973, as well as for conducting the prosecution of Sessions Case number 19 of 2023. And as to why, and for further direction for prosecution sanction against the accused police officials under section 197 of the said code. It is seen that an affidavit has been filed by the Superintendent of Police CID on 27/9/2024, wherein it has been categorically mentioned at paragraph number 9 that it was a clear case of cold-blooded murder, and as such, it is not a case, and it is not an action which was taken while discharging government duty. It was further mentioned that as such, the prosecution sanction under section 197 of the CRPC is not required. In addition to that, it has also been mentioned at paragraph number 10 of the affidavit that a special public prosecutor may be appointed to conduct the trial of Arangajo ES case number 3/2020. So taking into account the said stand by the responding authorities in the affidavit, the senior counsel appearing on behalf of the petitioner submits that the instant writ petition can be closed with a direction that the special public prosecutor be appointed at the earliest so that the sessions case number 19/2023, which is an ongoing proceedings, can be proceeded with at the earliest, taking into account the said submission, which is not being opposed by Mr. H. Sharma,
Already they are in the affidavit. Already they are in the affidavit on it.
opposed by the Mr. This court disposes of the instant writ petition, thereby directing the respondent authorities to take immediate steps for appointment of a special public prosecutor for conducting the trial in connection with sessions case number 19/2023 at the earliest, and immediate steps for him, and preferably within a month, 1 month from the date of the instant order.
Yes, sir. Last occasion, the instruction was received, Lordship, in this record. I have gone.
Solution.
Regarding the solution, Lordship, I am praying for some time, Lordship. The council, Lordship, is out of station, who appeared on that day and unable to get his instruction, Lordship.
But in the extraction part, Lordship, Annexure D kindly see, Lordship. Circle officer already forwarded the matter to the SDO, Lordship, local BDO, Lordship, for consideration. But in that aspect, Lordship, if they allow, Lordship, may direct to construct, we will construct the bridge or culvert, anything, Lordship, for our town.
Lordship, that can be done, Lordship. That's because now they were allowed to
Later part,
temporarily
Lordship, some,
doing some by bamboo bridge, Lordship.
no, we have no any debate.
No, honorable, yeah.
No, please, not bamboo bridge, A1.
AU Ahmed, the legal counsel appearing on behalf of the petition, as well as Mr. H. Sharma appearing on behalf of the respondents. The instant petition has been filed by the petitioner, being aggrieved by the demolition of the bridge constructed by the petitioners. By the demolition of the bridge by the district administration, which was constructed by the petitioner. Petitioners were aggrieved that on account of the demolition of the bridge, the petitioners were not able to use their patta land.
Residents.
And the ingress and egress to their land were greatly impacted. It is seen from the various, it is seen that on 39/2024, where is that copy? 39/2024, instruction was placed dated 12/9/2024, wherein it was mentioned that on account of the natural drain from the hillside being blocked by some local people feeling by reversing of the sandy soil, for which there was a waterlogging problem, the action had to be resorted to by the district administration. It is also seen that the respondents are not adverse to petitioner constructing a bridge without affecting the drainage, so that the petitioners are in a position to ingress and egress to their land. The learned counsel appearing on behalf of the petitioner submits that the petitioner shall consult with
No,
the
my prayer, Lordship, if the authority allow us to construct a footbridge or any culvert, Lordship, or through a pipe, Lordship, so water can flow, Lordship.
that also
That
you'll
part-
consult with whom?
The petitioner.
What petitioner? Petitioner will consult with whom?
No, not consult, Lordship. I have just referred the instruction, Lordship.
In this instruction,
D-
also,
D-
after the drain was dug, the office of the BDO, Boitamari Development Block was requested to construct a bamboo
NHRD,
footbridge.
NHRD.
Where? Ah,
In the first page, Lordship, the fourth dot, Lord.
the petitioner is not averse to constructing a bridge for their ingress and egress to their land.
The culvert, Lordship, culvert.
Bridge of the culvert to the ingress and egress to the land without affecting the drainage over the drain. Taking into account the above, as well as the instructions dated 12/9/2024, which have been placed on record and marked with the letter X. This code permits the petitioners to construct a culvert oblique bridge so that they can have and they can ingress and egress to their land. However, it is made clear that in doing so, the petitioners shall not in any manner affect the drainage system of the drain.
Dispose of that. Dispose.
It's read.
Oh, yes.
The denial is again, my lord, today on next in court number 4. But my lord, I have taken instructions from the department. And I am being told, my lord,
Now tell me, what are you doing with that eviction matters after the Supreme Court's order?
Sonapur. That Supreme Court order is with regard to my lord demolition of houses only. It is restricted only to that,
Houses,
Okay,
not
okay.
eviction.
not everything. It
So you
is
can carry out the eviction, but not the house. You can't demolish them.
demolition. That is what I understand, my lord.
Yeah.
Lordship, in this case, I have been properly instructed by my client as well as by the government. So they will withdraw this impugned order and whatever appropriate order we have.
I think that is what
Yes.
I said on the last.
And government also, after Lordship deliberation, have decided that that power will be delegated to DLR in the coming time.
The pit heard Mr. D. Chakravarti, the learned counsel appearing on behalf of the petitioner. I have also heard Mr. D. Saikia, the learned advocate general, assisted by Mr. R. Pujari, appearing on behalf of the state of Assam. The learned advocate general submitted that the state, after making deliberations, would like to withdraw the order dated 23/8/2024, which have been impugned in the instant proceeding. The learned advocate general, however, submitted that the withdrawal of the said order should not prejudice the state to take appropriate action as per law. Taking into account that the order dated 23/8/2024 have been is being withdrawn. And in that regard, the statement has been made by the learned Advocate General. Full stop. Nothing further survives in the instant writ petition. Accordingly, the writ petition stands closed. This court further observes that the closing of the writ petition as well as the withdrawal of the or impugned order dated 23/8/2024 shall not affect the rights of the state to take such action as otherwise permissible under law.
Highly obliged.
That day only I said that
Lordship. Well, one thing, the prerogative of the state vis-a-vis, the right of the petitioners also in case action is taken under Rule 26 to be given an opportunity.
We'll give them opportunity. That is my instruction also, that while passing a place order, if necessary, Lordship, we'll give them the opportunity of being heard.
it is further direct observed. I said as per law. So obviously that would mean that they would have to give, because if they do it, they will accept 26. If they don't give you, again, you are there, I'm here waiting for you.
Will also come. Highly obliged.
Same in 33, 34, same.
Beleg order. Deeply obliged.
Thirty-five.
Order. Yes. There are two plots. In one plot, you got the money.
Yes, madam.
One
No,
katha,
there was-
1 bigha, 5 let's say is the total plot, of which they acquired initially 1 katha, you got the money, but the requisition cost you have not got it. As regards 4 katha, 5 lechas, the petitioner has requested it to take appropriate step either to release it from requisition or to acquire the land. Pursuant thereto, they have acquired 4 katha but have not paid you the amount. That's all. Yes, what is the instruction? That I've seen it. But these instructions are not good. My order is specific. It's very clear, Principal. It is the specific case of the petitioner that the petitioner have not been paid the compensation in spite of the fact that the petitioner had on various occasions approached Mr. B. Chaudhary and Mr. B. S. Borua, the learning are directed to apprise this court as to what is the amount of compensation which the petitioner is entitled to in respect to the acquisition of 4 katha 5 letters of land by notification dated so and so, and why the said amount has not been paid. It's a crisp query. The answer should have been straightforward. What is all this thing? In respect to the query so raised, you tell me, are these the answers? I asked you what is the amount of compensation the petitioner is entitled to and why the amount has not been paid. That's all. What is your answer?
Earlier, this was the-
You know where your 4 kata 5 lecture land is? You know where your 4 kata 5 lecture land is?
Yes, it is a single plot of land, 1 bigha 5 lessa.
They have
And-
taken 1 kata
Yes,
and 4 kata 5 lecture, you know.
yes, but
Return the land. Return the land.
they have constructed the bridge.
They have constructed the bridge. You can break that thing. You can very well say out there some other day that the bridge where it stands is in my land. So you have a right to take toll. You give him the rights to take toll. You take it as your undertaking. You can't take their land like this. There's a good English saying, no? One should cut one's cloth according to the length or something. Isn't this your case? PWD has no money, taking somebody's land.
Petition, madam, I will
You give the money.
go, my lord, and receive that.
Don't give the land, then give him the whichever pillar it is. He'll take over the pillar. And without the pillar, if your bridge can stand very well. We give him the public because once he becomes the owner of the pillar, he has also the right of demolishing also. Let him demolish. You don't have the money, why do you do it? First, you have not got your instruction to that effect as to how much. Yes, you. You are also responsible equally. If Mr. S. Borua was appearing, now Mr. H. Sharma is appearing.
That is, but from the,
No, that you have acquired.
no, Lord,
Then if you have acquired, how much is the amount of compensation he is entitled to?
but that instruction I have not received yet.
Then-
Lordship, one thing is there. If the PW is not paying us the money, we cannot disburse it.
Forget about that. I am asking you, what is the amount of compensation he is
That,
entitled to?
that
We'll take it
instruction
up
I
with
do
the
not have till
PWD.
date. Till date, I do not have that instruction.
You can't go like this. You take over somebody's land. You
Yes,
first requisition it. Then you only take only 1 katha, acquire it and make payment. As regards the other amount, 4 katha, 5 lectures, you don't do it. You then acquire it. Who would pay the requisition cost? Nothing mentioned. Then I had done this. I handed this.
Lordship, that also.
Why shouldn't
I
we apply the same order which the GMC did in the morning to you?
Lordship.
Why this court should not apply the same order which the GMC did in the morning
Lordship, that
To
word,
you.
Lordship, yeah, that word.
to you also? Same?
No, that is Lordship, yes, that is a different part, Lordship, in a direction. But here, Lordship, if the money
Yeah,
is
somebody
not
must have
discharged,
directed you. You are not writing it, it's a different thing. You can't take over the land like this.
That I admit, Lordship, I have nothing to argue on that point, Lordship, but Lordship may kindly give us some reasonable time, what if PW is,
The simple question which I've asked, how much and when are you, why not paid? I'm not even asking you when you will pay. Why the amount has not been. Madam comes up with some instructions which have no head or tail with these queries. They say that we don't know anything. We only know to make the road. Okay. This court had sought for specific instructions by an order dated 29/2024. However, both the PWD as well as the district administration have not apprised this court with the instructions sought for. Accordingly, list this matter on 11th of November 2024. Both the district administration as well as the PWD are directed to file and bring on record their stand by filing an affidavit on or before 6th of November 2024. Failing which, this court shall presume that the land has been taken without following the due process and have violated the mandate of Article 300A of the Constitution and pass appropriate orders thereafter.
Only regarding that query only.
Earlier affidavit, earlier I was restricting to the query, now I am asking you to file an affidavit.
Regarding.
But that is the only thing, nothing further remains. There are three things. One is how much amount he is entitled to, when, why payment not made, and what is the amount of requisition, and why payment not. Paragraph 7. Yes, Mr. GMC.
Here also, Mr. Here would appear through PCI. Mr. Here supposed to appear through PCI, but probably some technical glitches.
Ooh,
Mr. Here. Through PCI probably he would have appeared, but some technical issues arise.
Okay. this is the matter of the vacations.
Okay.
53.
Covering all the districts. We have together one from one or two districts.
You have got the instruction from others.
Others.
Mr. BJ Talukdar, the learned additional senior government advocate, submits that he has they have received the instruction as regards the all the 23 districts, and as such we are filing an affidavit. List this matter again on 13th of November 2024. The affidavit be filed by 11th of November.
54.
HRHO. Oh, yes, done. Filled it.
Let us wait for High Court's order.
Okay.
Kindly grant me
No,
one last opportunity.
no, nothing doing. I'm setting aside, I'm passing an order to the effect that this is absolutely in violation of Article 15 and this is not done. On religion, it goes against the preamble. Have the preamble of our constitution changed, Mr. Bocceji?
But they are praying for some time, they are getting some inputs from the judicial department and therefore.
Forget about the judicial department. These judicial department and all this, they cannot make all these things. On the basis of a non-existent document, you have done it. It is absolutely in violation to our preamble. You can't transfer. Where is the Transfer of Property Act? There is anything to do.
Can it be on the reopen? Can it be on the reopen?
No. No
By the
reopening.
time- Try, because it's short time, from 27, I already communicated.
They have informed the petitioners. They look here, we'll wait for what the High Court says. If this is the conduct, I gave you a chance only for that. That don't invite a comment from this court.
No, that is from the district administration, but the department is pursuing this matter. That is what I'm told.
The department is not, I don't understand why the district administration has said that.
Then-
Let's hear the district administration tomorrow. List the matter tomorrow at 10:30 AM. On which date? At 10:30 AM. The Mr. J. Hendrick shall provide the video conferencing link to the district. What do you call? The district commissioner. Karimganj, who shall be present to the video conferencing. link. District commissioner, and the district register is the same. District commissioner, Karimganj, who shall be present at 10:30. This is not done. Don't invite the comments unnecessarily. You are raising on respect to something which is not there. Goodness. Why don't you ask the revenue department out there? Tell them authorities. Or does the revenue department has no control over the district administration? Am I to understand that? Can't have this. Tomorrow at 10:30, let's see his face. Give the video conferencing.
Or orders. Thirty-six.
Nobody is interested in such a old matter. What is the matter about?
I'm response number 7, 10, 11, 12.
What is the matter, Mr. Sikdar?
Allotment of rooms in a supermarket, Howdy Town. And the private respondent, my lord, they are the occupier, my lord, of the premises since long back. Their premises
No,
were taken.
None appears on behalf of the petitioner on call. It is further seen that on the earlier occasions also, the petitioner is not represented. It seems that the petitioner have lost interest in the instant proceedings, and accordingly, the petition stands dismissed for non-prosecution. Mr. A.R. Sikdar appears on behalf of the private.
37.
What is this?
This is a PF matter where the receiver had to be completed. The receiver was completed, service was to be carried out. This is the first listing after the service is complete. So the issue is with regard to how much recoveries have already taken place because the garden has been with the authorities for over 7 years now. And it's passed through 3 different authorities. First, the district administration, then the recovery officer, and then finally the receiver.
Mr. Das, you are appearing for whom?
Petitioner is-
Number 4, 5, and 6, my lord.
4, 5, and
That
6.
we have authority, my lord.
You,
One number 7, the receiver.
what is the receiver?
Running this.
Who is 7? 7 is not here.
They amended.
Yeah, we had filed the amended memo of party.
Is it?
There was an implement order that was passed on the 20th of December 2023.
Who is the receiver?
Lakshmi Khatam Tea and Trading Company.
How much amount you are due?
Original amount 1.5 crores. My instructions are not, all of it is over. There's still some to be met.
No, you have no business now for the time being.
I'm running it.
No, you may run it, that is, whatever may be, what is the provident fund doing? And what is your basis of giving it to them in this manner? How much are you taking the amount and how much you are adjusted against the dues?
This is the instruction 2023.
No, this is the difference, how much you are realizing.
Debt collection account letter dated 19/9/2023, my lord. The total recovery certificate amount was 1,25,98,226, my lord. As against which he has deposited 83,98,736, my lord. The balance was, my lord, 41,99,490, my lord. Plus, you have
No,
this
what is your
statutory interest.
basis? What is your basis of taking this amount?
They PF dues, my dad. They defaulted.
No,
in
no.
making
What
deposit.
is your basis of taking that amount from the private respondent? How are you
No,
taking?
they defaulted, my lord. They defaulted.
They may
for
deposit
making
tomorrow
deposit
5
of-
rupees also. Mr. Das,
My
they
lord.
may deposit 5 rupees also. But the question is, what is your basis? You are after all a state authority. You have to categorically say that how much they will be depositing and how much it will be adjusted against the dues of the petitioners.
And that has been, in the next page, that is there.
Yes, sir.
The other
Because
one?
the-
Yes.
Two Mr. Dases. If I allow the present instruction, instruction of 1st of October, the receiver is paying due regularly or not. Allow
Huh?
the areas. And this is the present instruction 1st of October.
What is the basis?
Your Honor, the basis seems to be minutes of a meeting that was held by the
No.
DC.
Wait. What is your basis?
They have defaulted it.
That is for taking over.
Yes, Your Honor.
But however, what is your basis of adjusting? Means, isn't that the basic reason why you're taking it?
Yes, Your Honor.
Then
Minus of
what
first
is the
month,
basis
just
of your adjustment?
May I?
No, take your seat.
There's an
I have
agreement.
nothing to do. What is your basis for your adjustment? You are taking and giving it to them, it's okay. You
Madam-
can very well, you
Madam-
have the power. But what is your basis of the adjustment? Or is it for the 1000 years you are going to do it?
There is an agreement between the present receiver, Your Honor, for running the.
You are having an agreement with the receiver, very well. But what is your basis? What is your consideration? And how are you going to get the realization?
This is the agreement, Your Honor. And
What is the agreement say? How much are you adjusting against his dues?
Well, then Your Honor, I will be allowed to place the agreement, Your Honor. The file between the.
Show me that.
Between the private respondent and the authority, Your Honor.
Where?
Because the agreement is not on record, Your Honor.
Oh, then we say that there is no basis.
There is an agreement, but.
No, there is no basis. Absolutely. You cannot be doing it at your sweet will that you will allow him that the private respondent will pay tomorrow 1 lakh rupees. Day after will pay 1 lakh rupees. What is your basis? If you don't have the basis, your actions are wrong.
File the agreement.
No, what is this? This matter has been pending from 2017 and we are to here today. After 7 years, you don't bring it. He has been fighting out here on the basis that for the last 7 years, they have given it to somebody, but they have no basis on which you are adjusting. You give me a piece of paper out here. This piece of paper says that in the year 2017-18, they paid 4,88,000. April 2018 to March 2019, there is one financial year, they have paid some 18 lakhs. Then April 2019 to March 2020, they have paid something around 21 lakhs. Then April 2020 to March, they have paid 19 lakhs. What is your basis and how much you are adjusting? Deposit position of green leaf cess.
Yes, Your Honor.
This is a green leaf cess, but how much you are getting so that you are adjusting?
Your Honor, kindly allow us to find the register of being on record. If I have an additional affidavit, let it be clear.
Because your action has to be fair.
Yes, Your Honor.
You can't be in this manner.
And there's one issue of the inventory also. There's a requirement that whenever a takeover of this nature takes place, an inventory has to be prepared. So I believe an inventory is not being prepared.
Yes.
If there is.
Provide the inventory and which you have done it.
Yes, Your Honor.
List this matter again on 6th of November 2024, on which date the Provident Fund Authority shall place before this court on the basis of an affidavit as to how the amounts, as to how the amounts received from the private respondent are being adjusted against the dues of the petitioner, and what is the basis thereof. In addition to that, they shall also bring on record by way of an affidavit the inventory list which was prepared at the time when the tea estate was handed over to the private respondent number 7.
Lordship, may I, since he's impeded me as a party, may I take your lordship in turn?
No,
How like-
you have no business. First, let me be satisfied with him, then I will pass an order to you. As of
Oblige,
now,
Lord.
for you,
Oblige.
we can incorporate your name on.
39.
Yes, none appears for the petitioner. Why the petitioner not appearing, Mr. C.K.S. Burua?
see if perhaps on the last date also.
What is the matter about?
Basically, it was unloading of vehicles from that area of railway lordship. And railway
Why the
department
matter has come up? This is item number?
39.
Sent to the disposal as disclosed on withdrawal, huh? The connected WPC number Iman and Iman. Okay,
No, lots of.
so the connected requisitions have been disposed of on withdrawal.
That I have no information.
The connected WPC and so sent to the civil disposal as withdrawal on here. So therefore, they must have withdrawn.
Those was as part of the 25
Yeah.
24.
Appears.
Did not appear.
None appears on behalf of the petitioner on call, which is further seen that the connected requisitions have also been withdrawn. Connected requisition filed by whom?
I guess.
But there were three requisitions take together.
Okay, this matter is usually comes in individual.
Conducting council.
Not as I have
continues to the next building. Yeah, anyway, none appears on behalf of the petitioner on call. It is further seen that on 21/6/2024, the conducting council was not present, for which this court had granted an opportunity, thereby fixing the matter on 25/7/2024. On 25/7/2024 also, the petitioner council was not present. Today, the petitioner council is also not represented. Seems that the petitioner have lost the interest in the instant proceedings for which the petition stands dismissed from non-prosecution.
Awesome.
He appears for, you appears for the union, huh?
Yes.
You also appears for. 14, huh? Yes, you have to file reply. You are not filing it.
Lordship, if they have not filed, if your lordship gave some time, I can file it.
It's the matter after we.
Okay. You want?
Service is completely is the matter of the petition. Sorry.
Right.
42. 41 after vacation. Service is complete. 42, no reply affidavit has been received. Who is going to file the reply? Going to file affidavit?
So, after petition. Lordship,
Seriously, that is what. This is the matter of the petition. But the request to the. 43 rejection.
It's Ray.
Where is this Mr. Siladitya? Whenever he appears, the matter is. Who is it? This court, pursuant to the order. If he is not appearing, why should I? This is the matter of the vacation. Now, this court have duly perused the report submitted by the registry dated 1/10/2024. However, as the petitioner counsel is, applicant's counsel is not represented, list the matter of petitions.
44.
Service incomplete, list the matter for admission of the petitions.
Who's the IA first to lord?
What is the IA for?
Lordship was filed by the respondent number 5, your lordship, praying for a change of date, your lordship. That can be closed.
IA filed by?
Respondent number 1 and 3.
Who is respondent number 5?
1 and 3.
Who is respondent 5? You? No, there is no respondent. There is only 3 respondents.
Persona 1 and 3, your lordship.
1 and 3 lord. Speaker and the secretary.
An application for taking up the instant writ petition on 26/9/2024 instead of 27/9. Today is 27/9.
Lordship, last week, lordship.
Oh, yes, then what happened?
Lordship took up the matter, lordship had fixed.
So this has become infraction. Who has filed this?
Lordship 1 and 3.
The instant application, Mr. Swenso appearing on behalf of the applicant in IA C 113 of the 2024 submits that the instant application has become infructuous. Accordingly, the IA stands corrected. Yes, now what is this?
The main case, lordship, respondent number 4 has filed their affidavit this morning, your lordship.
4? Who is 4?
The person against whom is near disqualification.
Then?
They filed their affidavit this morning, your lordship.
Then?
So, well,
Now, who is appearing for who has filed the affidavit stating that they want time till November?
Lordship, we have filed. Lordship.
Who are you?
Lordship, I am for respondent number.
Mr.
1 and
Bhattakuri, you are appearing for whom? Huh? Yeah. And who says 1 and 3 is who?
1 and 3 is his lordship, 1 is the
Secretary.
speaker, and 3 is the secretary of the assembly.
What does it say?
Lordship, we have
First
given a
notice
schedule.
was issued and being made and extension was from the none.
My lord, from the speaker's side, in the affidavit, they have indicated that by 3rd week of November, they will dispose of the whole matter. At this page 164, the affidavit starts, and the operative portion is at page 170. Subpara R. That the honorable speaker would be pleased to pass the final order disposing of the proceedings pending before him by 3rd week of November.
Wait.
Lordship, page 170.
Page 170, continuing page, para 2 small r. He says that he has some international engagements. So he will be coming back on 9th of November. So he says by 3rd week of November, he would pass the final order.
Oh, you're okay?
I think it's okay.
List this matter again on 25th of November 2024. Pusta. Yeah, 2024, taking into account the affidavit filed by the respondent number 1 and 3, wherein it has been categorically mentioned that the final order disposing of the proceedings pending before the honorable speaker will be passed by the 3rd week of November 2024.
All right.
Yes.
As regard the item number 43, madam,
Yes, you are not present when the matter is called.
I was just, madam, in the civil court due to rain, madam.
Rain?
Raining, my lord.
Floods? No flood. Anyways, wait. You pass the order. You going to man? 57. Affidavit regarding justice service with regards to. Yes, who is appearing?
That's why, my lord, I have to instruction to appear on behalf of respondent number 6, my lord. My lord, I'll file affidavit, my lord.
Oh, yes. No, this is not a case of delay. What is your case? 60 years. He has
Correct.
considered more than 60
This
years.
is the instruction. So in terms of page,
Why is the assistant registrar asking for maintaining status? What business does he have?
this.
Are these rules and regulations or the bylaws have no relevance? I'm asking you, you are an expert on corporation law. So I'm asking you.
If your lordship comes to page 18, if your lordship comes to page 18 of the writ petition, this is the order of the registrar.
Ah.
Now, the second para, societies may be asked to adopt the same as model service rules where they have no own service rules. Now, I am told, my lord, that there was an existing service rules which permitted up to 65 years. So therefore, my lord, that was directed to be inquired into. And here, my lord, this on instruction, my lord, is
What is this page 19?
page 19, my lord, it's a draft, my lord, service rule framed, my lord, by the registrar, where, my lord, no service rule exists, my lord, in the society. This draft exists, my lord, service rule may be adopted by them.
Ah.
This is what, my lord, the registrar says.
Ah.
And in case where, my lord, there is an existing service rule,
Ah.
my lord, they are not required to adopt it.
Do you have an existing service rule?
You are following this last service rule.
No, they are saying they are saying that there is a draft. That is a draft. Now the question is, have you adopted that rules? You can very well adopt any service rule. Have you adopted that?
Adding that take some time also.
Mr.
My lord, we make it part of the record because your lordship has directed me to obtain the instruction.
Adopted. Adopted.
Huh?
The service rule is adopted.
My lord, my instruction is that, my lord, I am appearing for the respondent, but I'll file affidavit. Bring on record that, my lord, there was already a service rule. In terms of, my lord,
Where is the service rule?
then I'll.
No, you say, merely saying won't do. You have
That is why, my lord,
instructions, means there is a service rule.
Immediately after reopening lordship cases, I'll file affidavit for that.
Okay. The pursuant to the order passed by this court on 29/2024, Mr. S.K. Talukdar, learned counsel appearing on behalf of the Corporation Department has submitted that that the service rule enclosed to the writ petition is only a model service rule. Is a draft of the model service rules. First off, it is as per the information of the Corporation Department. As informed by the respondent number 6.
6.
There is already an existing service rule of the society. The said aspect is presently being inquired into by the Corporation Department. In that regard, he has placed before this court the instruction dated 1/10/2024, which is kept on record and marked with the letter X. The learned counsel appearing on behalf of the petitioners shall make necessary submissions on the next date as to whether there exists any service rule of the society other than what have been enclosed in the instant writ petition. In addition to that, the learned counsel for the petitioner shall also apprise this court as to whether the service rule enclosed to the repetition have been at all adopted by the society in question. Mr. J.M.A. Chaudhary, appearing on behalf of the respondent, number 6, submits that he would like to file an affidavit. So, taking into account the above, list this matter again on 28/10/2024. The affidavit be filed on behalf of the respondent number 6 by 24th of October 2024.
Time being item 50.
Made future lordship. Lordship has gone to the impugn order. Since the, my lord, issue is need to be decided by the Director of Land Records. Until then, my lord, he should have restored the position. On the contrary, my lord, he has taken a stand which goes against my interest. If your lordship would kindly come to page 40. My lord, lordship knows the background. Actually, there are two Moses. One is my lord Govardhana and other is Howli. And I am the Mojader of Howli Moja, my lord. And for quite some time, Borpeta Road town was allocated to Howli Moja. That is how it is continuing. Now, the dispute is being decided by the DLR. Please come to page 40.
Yes.
Reference to the subject cited above, I have the honor to state that regarding issue of collection of land revenue of Borpeta Road town, report was called from some circle officer Barnagar and also the Mojader of Howli Moja and Govardhana Moja were heard. As per the report and records available, Howli Moja has been receiving dole, that is the demand, my lord, from Borpeta Road town since 75 till 2012-13. For the year 13-14, the said dole was issued against Govardhana Moja as well as Howli Moja for collection of land revenue against Borpeta Road town. Again, the said dole was issued to Howli Moja for the year 2014-15. Since 15-16 till that dole has been issued to Govardhana Moja. However, land revenue against Borpeta Road.
Since 2015-16 till date, the dole has been issued to Govardhana.
Since 15-16 till date, the said dole has been issued to Govardhana Moja. However, the land revenue against Borpeta Road town is collected by Howli Moja from 75 till date, and Govardhana Moja has not collected any land revenue against Borpeta Road town till date, and the records are maintained by the Howli Moja only. No office record is available about the authority and its decision of number 1, allowing Mojader of Howli Moja to collect land revenue from Borpeta Road. B, separation of dole of Borpeta Road town from Howli Moja to Govardhana Moja. So records are either in case not available. As per revenue record, Borpeta town Road town is included in Govardhana Moja. So my lord, submit for your favor of information and necessary action. Then my lord will kindly come to the next page. Another letter is written by the office of the district commissioner. With reference to the subject cited above, I have the honor to forward herewith a prayer petition received from Khalekur Zaman Chaudhary, that is the petitioner, requesting to make necessary provision in online e-Khazana system to collect a revenue against Borpeta Road town. A public petition is also received in this regard. Borpeta town is included in dole of Govardhana. However, revenue is being collected by Howli Moja.
But Mr. Chaudhary, tell me one thing. What is the basis of collection of the revenue?
My lord, this arrangement is going on for quite some time.
Understood, but is it dependent on which moja, under which moja that they be?
My lord, actually, strictly speaking, my lord, there are some confusion at some level. That I will not say no. But the question is when DLR is in session of the matter. Now, could the DC have passed their order at page 42, my lord? Please come to that order for a moment. This is the impugn order.
No, that I've seen it, but
Yes.
how do you say that DLR is in session of the matter?
Because ATC has written to the DLR at page 40 and 41.
No, but whether the DLR is at all in session of the matter?
And in the impugn order itself, it says, my lord, page 42 for a moment.
Yes.
Since Borpeta Road town falls under Govardhana Moja and the same is also mapped accordingly in Dhoritri, therefore for convenience of public, Srimati Minoti Pathak Mojadar is hereby allowed to collect revenue against Borpeta Road
down for the time being, till receipt of any further instruction from the Director of Land Records and Survey. And my lord, till that I am receiving. Though, my lord, it is shown the dole was issued for the Govardhana, but till that I am collecting. Till yesterday, till now also, my lord. Because the report itself says the revenue is being collected by the Mozaddar of Auli. And my lord, Deputy Commissioner is not the authority to decide all these things. As per Executive Instruction 153, it is the state government who will do it with us. Deputy Commissioner cannot take this decision. Please have Executive Instruction 153, my lord. And no notice, no nothing. One 53. Previous sanction of the government should be obtained to the division of Moza. In applying for sanction, the revenue demand of Moza, which is proposed to be divided, as well as the demand of each of the new Moza to be formed out of it, with reasons for proposed change should be given. A map or trace showing the existing and proposed boundary should also be submitted along with the proposal. So everything can be done, but the Deputy Commissioner will forward all these things to the state government. So Deputy Commissioner has no power under the scheme of the Land Revenue Regulation to take an unilateral decision as has been taken here.
The only question is, who is to collect the Moza?
No, till now I am collecting, maybe my lord, maybe
be-
tomorrow
It
if the
is to be
government
collected
decides.
by the Mozaddar.
Yes. Now, if your lordship kindly comes to page number 40, my lord. Now, the Mozaddar of Howli is collecting
But the land revenue, the Mozaddar duties shall be confined to collection, and he shall have no concern with its assessment, the settlement of land, the checking of maps or area. The Mozaddar, however, is responsible for reporting any systematic or extension, omission of land from the assessment on the part of the record. But if Borpeta town falls within this Moza,
Actually, my lord,
how can anybody else collect it?
no, question is, my lord, there is no clarity. In fact, my lord, after filing of the case, ELR has written a letter to the Bongaigaon DC, my lord. Can I just place it?
I'm only used to this type of papers only.
To at 4:30, my lord.
No. Most of the matters I put it on the instructions and finish it off.
Yes.
Yeah.
And you see, with reference to the subject cited above, I have the honor to mention that as per letter under reference 1, it has been observed that there is lack of clarity on the records pertaining to transition of dole from Howli to Govardhana for collection of land revenue in respect of Borpeta Road Town. Therefore, you are requested to furnish the same for taking further necessary actions.
Okay, you want the stay.
Yes.
Now, if I grant the stay,
No, my lord, only thing is I should be allowed to collect the revenue of Borpeta Road Town as I am doing in terms of
therefore
page
you want the
40.
stay.
Yes.
Now, if you want to stay tomorrow, if you lose the case, then what happens?
Ultimately, the revenue will go to the state, my lord.
No.
Or
You
that
take
25%
10%.
commission.
So you
Yes.
will, you preserve, maintain an account
Yes.
as to
Yes. If
whatever revenue
eventually-
is being
if eventually
collected.
The decision goes against me.
Again, whatever revenue is being collected after the impugned order dated 26.
I should be prepared to return.
I think that will be a fair.
Yes.
Because otherwise it goes to the state.
Yes. Whether I collect or somebody else collect.
Yeah.
Pursuant to that data that just now my learned senior friend has placed.
Uh.
Against that, most probably this page number 40 and 41 are the reply. This is by the additional deputy commissioner to Director of Land Records. Reply to yaate ache. I think the reply.
No. This document, which is the shortly had placed, is
110.
1/10/2024. These are of 26/9.
66.
And-
66 and 19.9.
No, this is the interim order is the 26th.
No, my lord, my learned friend says page 40 and 41 are perhaps the reply. These are of June and September.
Maybe, but their reply is there, Lordship. There may not be the reply of that letter. But
No, it's
the
okay.
the query.
No. We will consider that. The thing, we'll look into it, but we will stay it subject to this 10% which is there now as per the instruction which is there.
Yes.
I also want to point out,
Uh-huh.
Lordship, that is at page 41.
Yes.
Presently, offline records are being with Hauli Musa, that is with the petitioner. But online dole is with Gubodona Musa.
But here he is only concerned with Musa, what is the collection?
Borpeta Road Town, my lord.
Borpeta Road Town Musa
It's
regarding that
hereby
offline.
allowed to collect land revenue, e-khazana and e-CFR against Borpeta town for the time being. Till receipt of any further instructions. Land revenue is that Moza,
Yes.
Yes, Lord, of that Borpeta Town.
e-khazana and e-CFR. What is e-CFR? CFR will be
Counterfoil receipt, I think. Counterfoil receipt.
counter for receipt against Borpeta town for the time being till receipt of any further instructions. Anyways, the government is also in a position. You see, if I give a stay out here, then asking him to maintain a particular
Account.
accounts would be better. But if I give a status quo, to this, then it again makes it unclear. So I think the better, because here the respondent number 6, the amount is going to go, because this is also made as a interim measure. This was, has been
But
made. in-
regarding that commission part, your Lordship would
Ah,
respect that.
Commission, I am doing it now.
Lord.
Where is the commission? Election of where I got it somewhere, commission.
Earlier it was 25, now I think it is 30.
No, it is given here somewhere. Muzada is a man, is commission. Payment of process fee, warning, solution.
Whatever is the Mogadar's commission. my lord.
I saw it somewhere just now.
I think, my lord, depending on the publication, now the percentage has gone up. Initially it was 10%.
No, it is still there. It's, I saw it.
So I
here.
think, my lord, by way of, I think 159,
159, yes.
no, 159, yes.
Yes, yes.
Mozada
No,
will
yes.
receive commission at 10% or on.
Yeah,
collection.
159. Mozada will receive commission of at 10% on all collection made by him. Morsida will receive 20% on the second kiss. Mozada will collect the second kiss only and will also receive commission of 20%.
My lord, I think this is gone.
Now, as per the
Whatever is the prescribed rate.
or Mr. Page, the learned counsel, senior counsel assisted by so and so. The counsel appearing on behalf of the patient. Mr.
One by my learned friend, 1 and 2.
Yes, madam, you are the main person. D. Hazarika appears on behalf of the respondent number 1 and 2. Mr. H. Sharma appears on behalf of the respondent number 3, 4, and 5. As the respondent numbers 1 to 5 are duly represented, extra copies of the petition be served upon them during the course of the day. As regards the respondent number 6, the petitioner is directed to take steps by way of registered as usual. I issue notice to the development notice making it returnable 11th of November 2024. Full stop. As regards the respondent number 6, steps be taken by way of registered as well as usual. And within by tomorrow. In addition to that, the petitioner is further directed to effect service upon the respondent number 6 by way of dusty repeat through the registry of this court and file an affidavit of service on or before the next day. The case of the petitioner herein have challenged the order dated 26/9/2024 passed by the District Commissioner Borpeta, whereby the Borpeta Road Town, whereby the respondent number 6, who is the Muzadar of Govardhana Muza, was permitted to collect land revenue bracket E dash Khatana and E dash CFR bracket close against Borpeta Town Road for the time being till receipt of any further instructions from the Director of Land Records and Surveys. Full stop. It is apparent from the perusal of the record that apparent from the perusal of the record that the matter as to which of the Mozadas as Mozada should collect the Moza in respect to Borpeta town. That's the issue. It's apparent from the materials on record that the issue as to whether the Mozadar of Gobardana Moza or the Howli town, Howli Moza, would have the right to collect Moza in respect to Borpeta Road Town is a issue pending before the Director of Land Records and Surveys. Full stop. And there are various instructions also issued by the ADC Revenue of Borpeta to that effect that from 1975 till date, the Govardhana Moza had not collected any land revenue against Borpeta Town Road Town, and the same have only been maintained by the Howli Moza. Taking into account the above, this court is of the opinion that the impugned order Mr. Ken Chaudhary, the learned senior counsel appearing on behalf of the petitioner, submits that when the petitioner, who is the Mozadar of when the Mozadar of Howli town, Howli Moza, have been all along collecting the Moza for the Borpeta town road, as is apparent, admittedly, which is apparent from the communication issued by the additional district commissioner revenue, and the matter was pending before the Director of Land Records and Survey, the district commissioner Borpeta ought not to have passed the impugned order. He further submitted that it is not the function of the district commissioner Borpeta to exercise such a power. Rather, that power could have been at best exercised by the state government. First, taking into account the above, this court is of the opinion that pending notice is of the opinion that till next day, the impugned order dated 26/9/2024 is required to be stayed. First, this court, in order to protect the interest of the respondent number 6, this court have also taken note of that whether the Mozada of Howli Moza or Govardhana Moza collects the land revenue, it is the state government who is going to get the said revenue. Be that as it may, in turn, it is seen that the Mozadar of the Moza is entitled to certain commission. Taking into account, in order to protect the inter-party interest in the instant proceedings, this court directs that the petitioner herein, who is the Mozadar of Govardhana Moza, of Howli Moza, shall maintain records of the Moza, shall maintain separate records of the collection made in respect of Borpeta Town Road. Road Town. Borpeta Road Town. And Road Town. And also the commission which would accrue thereof.
Correct.
Item 28.
28 lordship, I have received the instruction.
Oh, yes.
That amount. It is received on 1st of October in the treasury. And after making all these formalities, they undertake to give the amount. Certain formalities are there, lordship. They have stated that within 2 weeks, it can be disbursed to the petitioners.
Who is going to pay the interest?
That
2
part
weeks?
I have not asked.
No, you have to pay.
Good lordship.
The indemnity bond as required is already submitted on first, my lord. Now they are saying that they will ask for a Mandal report, my lord.
Huh?
They are saying that they will ask for a Mandal
But
report.
they undertake to
That
make the
is-
payment within 2 weeks, lordship. So most probably they have forgotten about this. Puja holiday, lordship, within 2 or 3 weeks.
They don't have puja holidays. They have only 3 days puja holidays. And this time puja is also for 3 days.
They undertake to make the payment within 2 weeks, lordship, after this formality, lordship.
It has been submitted by Mr. A. Hooper, the learned counsel appearing on behalf of the JAD, that the amount payable to the petitioner have already been sanctioned by the finance department, and the said amount have also been disbursed to the office of the district commissioner, Kamrup Metro. In that regard, the learned counsel have placed before this court an instruction dated 1/10/2024, which is kept on record and marked with the letter what X, Y, Z, anything X. How many X is there? X, Y, Z. Gustav. This court had inquired with Mr. H. Sharma, the learned counsel appearing on behalf of the district administration, as to when the said amount would be disbursed to the petitioner. The learned counsel submits that
For the telephonic instruction.
that submits that that as informed to him by telephone, the said amount would be disbursed after completion of certain formalities and within a period of 2 weeks from today. Gustav, list this matter again on 23rd of October 2023 to apprise this court as to whether the amount have been duly disbursed to the petitioner. Gustav, it is further observed, award passed. Award passed.
I have not got out the statement.
Award passed or not?
That's-
Award
the thing-
must be passed, otherwise why will you pay money? Award passed.
Form, the second.
What?
Form C,
What?
ceiling, fixation of ceiling.
No, that is not that, but award is there, my lord. Page 64, my lord.
Huh?
Page 64, my lord. The award statement is there, but then the final.
Okay, no, that statement is okay.
My lord. Estimate. of
Where,
that
where? So
cost.
64 is not award, where?
Page 64, my lord, of the affidavit by the deputy.
Revised rate is this. No, this is not the award.
It's not the award.
This is not the
After,
award.
my lord,
This
the-
is the, this is the estimate.
My lord, after
This
section
is under rule Iman 203. Prepared. In other words,
after section 6(1), they had sent this estimate for
under section 60. Commissioner Iman. On the next day, the learned counsel appearing on behalf of the district administration also shall place before this court as to whether the award have been duly passed. এইটো মই ক'ত গ'ল মিষ্টাৰ শিলাদিত্য সেই তাৰ মতে থাকে। You see the report, they are going to go manually, they'll do it. এইটো এটা essay এটা আছে ন? Yes, Mr. Mishra, what is that? Dismissed for default. No, that is, you are asking for certified copy, you must have got it. What is there? The matter is for certified copy. None appears for the petitioner. It has been dismissed for non-prosecution. With disposal of with the cost. Unnecessarily. For certified copy, you file a writ petition. What is gone? What is this? The leniency in which the sport has been helping you out is. Okay, I'll pass that order to the effect that you will be, and they will correct and give it.
Obliged,
We'll dispose it of. Dispose it. I will dispose. What?
Otherwise, I might be in difficulty, my lord.
Huh?
No, not pays maybe, may not be recorded, otherwise I will be in difficulty, my lord.
You will be?
In difficulty, my lord, because client will ask, I have not appeared, my lord. In some,
Call up that fellow and ask him as to whether that, and inform them as to whether the certified copy has been received or not. In order that you are in difficulty, that person, you must be having his contact.
yes, ma'am, I will be calling
Call him up and find out and inform.
my lord.
Then if you inform him that yes, you have received the certified copy, so we'll put it at not pressed. But otherwise, if he has not received it,
My lord.
then to non-prosecution is the best. Non-prosecution, or I'll pass an order. First you find out them
My lord,
and inform them.
my
I'll
lord.
pass that order. Otherwise, if he has got it, it's okay. Otherwise, I'll pass an order to the effect that he will